Good afternoon to all of you. Can you be little louder? Okay. Online students, please give me a confirmation. Online students, is it audible? Okay, we are middle of, almost at the end of the topic of executives. So, how many questions you have covered till this point of time? 150 questions. So, today we will complete the entire executives and then I will start the legislature part, which includes both your union as well as the state legislature. Now, the idea is today once we complete the legislature, which I am not sure we will be able to complete the legislature, but I think we will cover at least almost the legislature part. Once the legislature part is done, from whatever you have done till this point of time, that is the first part, the philosophical part, including the fundamental rights, DPSP, fundamental duties, then we have done the executives, then we will also do the legislature, which will complete it today. If we complete, then you are almost ready for 8 to 10 questions. This is the majority of the questions that is likely to come in UPSC. So, therefore, that is the reason I want to do this first. And after that, we have a number of other topics which we will also do, but that will be roughly around 5 to 7 questions, assuming that UPSC is asking 15 questions. So, what are the other questions that I will take? The other questions that I will, the other areas that I will touch upon is judiciary, then I will go to the center-state relationship, then we will discuss about local bodies, which is Panchayat and municipalities. Then we will discuss about the constitutional bodies as well as some statutory bodies. Then we will touch upon topics like schedules, amendments, articles, and then apart from all those things I will touch upon political themes, and then finally I will also touch upon the miscellaneous areas. I am also planning to cover the historical underpinnings part also. So, there also one question is likely to come. So, wherever it is possible I will try to touch upon these areas also. So, covering all these things, how many questions we will be doing is around 500 questions. So, this is what is the plan. So, the idea is that if you have done your basics and along with that if you can revise these 500 questions, I am sure that you will be able to do more than 82 or 90% of the questions also. We cannot focus on 100%. If somebody tells that you can do all the 100%, that is not possible, because there is no limit to UPSC as to what kind of questions that they can ask. One such example is question number 151. So, these are all the questions that you can never predict. So, therefore, 100% question should not be the approach. You should try to maximize your effort. Okay, so that is what we are planning to do. All right. All right. So, please settle down. We will just move on to the next question. Shall I proceed further? Yes? Yes? Okay. So, we will move to the question number 151. Okay. So, please settle down, all of you. Okay. So, look into the question number 151, which is part of the executives. With reference to the union government, consider the following statements. Statement 1. With reference to the union government, consider the following statements. 1. N. Gopalaswamy Iyengar committee suggested that a minister and a secretary be designated solely for pursuing the subject of administrative reforms and promoting it. This is a question that you cannot expect. It has been asked randomly, but factually this particular statement is wrong. So, N. Gopalaswamy Iyengar, who was a member of the Constituent Assembly also, and he was also very influential number of committees that was appointed by the government of India. So, this committee was appointed in 1949, where he has primarily discussed about the reorganization of the central secretariat and also to bring in administrative efficiency into the government. So, although he has given number of recommendations with regard to improving the administrative efficiency, but he has not specifically recommended anything about what is called as creating a designated ministry and a secretary for pursuing administrative reforms. So, this is something that he has not suggested. So, majorly his recommendations were related to improving or reorganizing the central secretariat. Okay, so therefore this particular statement is wrong. So these are all questions you cannot predict. In case in the examination also, if it comes, if you are lucky enough, it is okay, because it is only purely based on luck. We are not going to the examination. So when you are preparing well, luck will also favor us, but purely based on luck, we should not go to the examination. That is not the right approach. Okay, so therefore even if the luck is not favoring also, we should be in a position to clear it. That is how your preparation has to be. Okay. Okay, so this particular statement is wrong. In 1970, the Department of Personnel was constituted on the recommendation of Administrative Reforms Commission 1966, and this was in place under the Prime Minister charge. Is it true? Yes. In 1970, the Department of Personnel was constituted on the recommendation of the first Administrative Reforms Commission, and the Department of Personnel and Training today is directly under the charge of whom? It is under the charge of the Prime Minister. Below the Prime Minister, there is a Minister of State who might look after this, but however, it is directly under the charge of the Prime Minister. The Minister of State only assists the Prime Minister. Okay, so therefore this particular statement is true. So which of the statements given above are correct? So what is the answer here? It is 2 only. Okay, so please come to the question number 152. Consider the following statements. The Constitution of India classifies the ministries into 4 ranks: Cabinet Ministers, Minister of State with independent charge, Minister of State and Deputy Minister. The Constitution has no such classification. In fact, of all the things, only one thing that is mentioned in the Constitution is the Cabinet, not the other type of ministers. Always what is mentioned in the Constitution is only the Council of Ministers. This is only based on the allocation of business rules. It has no mention in what is called as the Constitution of India. So therefore this particular statement is wrong. The total number of ministers in the union government, including the Prime Minister, shall not exceed 15% of the total members in the Lok Sabha. Is it true? Yes, this is true. But however, this was brought in by which amendment? Very good, 91st Constitutional Amendment Act 2003. So in case of center, this is true. But however, in case of states, what is the answer? In case of states, it is also the case that it shall be not more than 15% of the members of the legislative assembly of that particular state. But however, if the minimum number of ministers will not be 12, then in that particular case, at least it has to be 12. Okay, so that is what is the general thing for the states. So this is true. Along with that, you also remember please the 91st Constitutional Amendment Act 2003. So what is the answer in this particular case? 2 only. If it is asking, yes, it is asking for the correct one. Please come to the next question. Consider the following statements. Statement 1. The Attorney General of India and the Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament. Now before that, please tell me whether the word Solicitor General, is it mentioned in the Constitution? The only word with regard to the law officer of the Union is the Attorney General, and with regard to the law officer of the state, it is the Advocate General. Now below that, to assist the Attorney General and the Advocate General, number of other law officers of the government is also there, but all those things are created only by the business rules, which can be created by the President and the Governor respectively. So therefore there is no mention of Solicitor General in the Constitution, and also this privilege is only given to the Attorney General in the Union level and to the Advocate General in the states. So therefore this particular statement is wrong. According to the Constitution of India, the Attorney General of India submits his resignation when the government which appoints him resigns. Is it true? There is no such requirement under the Constitution. The Constitution says that the Attorney General holds office and he holds office during the pleasure of the President. So therefore, the Attorney General normally will submit the resignation if the government changes, because the other government might make him to resign. But however, he does not, under the Constitution, doesn't have to resign. Okay, so therefore this particular statement is wrong. So it is not there in the Constitution. That is the idea you should have. So what is the answer in this particular case? The answer is, they are asking for correct one or the incorrect one? Incorrect? Correct. So it is, so therefore it is neither one nor two. Okay, so come to the next question. Consider the following in respect of the election of the President of India. The members nominated to either houses of the parliament or the state legislative assemblies of the state are also eligible to be included in the electoral college. The members nominated to the either houses. So therefore, the nominated members are not there. Anyway, so this is wrong because it consists of only the elected members and not the nominated members of the parliament or the legislative assemblies of the state. So nowhere the nominated members are there. So is there a provision for nominated members in the Lok Sabha today? Is it possible to have nominated members? What about the original constitution? Was there a provision for nomination? Yes, in the original constitution it was there, but today it is not there. By which constitutional amendment it was done away with? 104th Constitutional Amendment Act. So 104th Constitutional Amendment Act has done away with the nomination. So today this nomination is not there. But in the original constitution, 2 members can be nominated from the Anglo-Indian community in the Lok Sabha, and 1 member can be nominated in the Legislative Assembly from the Anglo-Indian community. So the president can nominate there, here the governor can nominate. But anyways, this particular statement is wrong. The higher the number of elective assembly seats, the higher the value of vote of each of the MLAs in that particular state. Is it true? The higher the value of the MLAs, the higher the value of MLAs, will it be higher the value of votes? Because if you look into the formula for calculating the value of vote of an MLA, population of the state divided by the elected MLAs. So therefore, if in the denominator more number is there, the value is going to decrease. So therefore, this particular statement is wrong. So this is also wrong. So higher means it will be lower value. The value of vote of MLA of Madhya Pradesh is greater than that of Kerala. So this is again based on your luck. So this is something which is not most of you can remember, and there is no need to remember also. So that's why I said that 100% approach is not possible even in certain areas UPSC. But the good thing about this particular question is 99% of the questions students will not be able to do it. If they get it by luck, that is a different thing, but they may not know it at the time of examination. So these are all the questions that you should not worry. So these are all, this should not be the approach based on which you will prepare. Your approach has to be on the areas where you can do it. But anyways, because it has been asked, now we know the answer, but otherwise it is difficult for us to know the answer at the time of going to the examination. So the value of vote of MLA in Madhya Pradesh is not greater than that of Kerala. In fact, Kerala has greater value. Okay, so this particular statement is also wrong. Now come to the last thing. The value of vote of each MLA of Puducherry is higher than the value than that of Arunachal Pradesh, because the ratio of total population to the total number of elective seats in Puducherry is greater as compared to that of Arunachal Pradesh. See, the population of Arunachal Pradesh is very less, but they got 60 MLAs, more number of MLAs. But whereas in Puducherry, the MLAs are less and they have a substantial population also. So therefore, whose value will be higher? The value of MLAs in case of Puducherry. So therefore, this particular statement is correct. This is again a very difficult thing. It is not a very easy thing, but yes, UPSC can ask such questions also, but that does not mean that you should look into all the states and remember the MLA value of all the states. That is not the approach. Okay. So how many of the statements given above are correct? One only. A is the answer. Okay, so come to the next question. Consider the following statements. If the election of the President of India is declared to be void by the Supreme Court of India, all acts done by him or her in the performance of duties of his or her office of the President before the date of decision will become invalid. Will it become invalid? No. Even if the election is declared to be invalid, all the prior actions that is done by the President of India would continue to be valid. I also gave a reason for this. Why this is considered to be valid? Two reasons in fact. One is it will create a lot of administrative inconvenience. The second thing is, anyways, the President is acting on the aid and advice of the Council of Ministers. So therefore, he is not taking any decision on his own. So therefore, these actions will be continued to be valid. All acts become invalid. So therefore, this particular statement is wrong. Election for the post of President of India can be postponed on the ground that some legislative assemblies have been dissolved and the elections are yet to take place. What about this statement? Whether the electoral college is full or if there are some vacancies, still the election has to happen on time. Okay. So because the constitution says there needs to be a president and every 5 years election has to happen. Okay. So therefore, this particular statement is wrong. And in fact, can you tell me what is the ground on which the election of the president can be challenged in the Supreme Court? Can anyone tell me what is the ground on which it can be challenged? What does the constitution say? The constitution does not say anything in this regard. Okay, so the constitution does not say what is the ground on which it can be challenged. The constitution only says what is the ground in which it cannot be challenged. So the ground on which it cannot be challenged is that there is a vacancy to the electoral college. Otherwise, the petitioners are free to challenge it on any ground. Then it is for the court to decide whether it is a valid thing or not. So very, very important. And in the last class, I also discussed about what is the ground on which, who can challenge the election of the president. Anyone who is part of the electoral college or anyone who has contested in the presidential election. Okay, so and there is also time limit. So UPSC may not go to this extent. So based on the President Vice President Election Act, so any election of the president can be challenged within 30 days after the declaration of result by the Election Commission of India. So anyways, UPSC may not ask, just an extra information. Now come to the statement number 3. When a bill is presented to the President of India, the constitution prescribes a time limit within which he or she has to declare the assent to the bill. This is not there. That is the reason why the president exercises what is called as pocket veto, because there is no time limit that is explicitly mentioned. So therefore, this particular statement is also wrong. How many of the statements given above are correct? These are correct. None of them is correct. So the idea of this class, it should be a revision to all of you, and wherever you have a gaps, it has to fill in those gaps. So this class should not be seen as where you are trying to learn a lot of things. It should be more of a revision, and of course, yes, certain new information you will also get definitely. Who among the following is or eligible to be appointed as an advocate general of a state? Who is eligible to be appointed as an advocate general? One who is qualified to be appointed as a judge of high court. That's the only qualification that is given apart from being a citizen of India. So one should be eligible to be appointed as a judge of high court. District judges, can the district judges be appointed? Not all the district judges, it is not possible. So anyone who has held a district judicial office for 10 years can be appointed as a judge of high court, but not every district judge is occupying the office for 10 years. We do not know that. So therefore this cannot be right. Advocates of high court having 5 years of practice. Yes, to be appointed as a judge of a high court, how many years of practice has to be there? 10 years of practice. So it is not 5 years of practice. So they will also not be eligible. So choose the correct answer from the codes given below. What is the answer? It is 1 only. Consider the following statements. Fixing population on the basis of 1971 census in presidential election, making cabinet advice binding on the president, allowing the president to send the cabinet advice once for reconsideration. Which of the above are part of the 42nd Constitutional Amendment Act 1976? Which of the following is are part of the 42nd Constitutional Amendment Act? Census was fixed to be 1971 census. Till what year in 42nd Constitutional Amendment Act? Till the year 2000. And only in the year 2001 again it was amended by the 84th Constitutional Amendment Act, and they increased it till 2026. But by the 42nd Constitutional Amendment Act they extended till the year 2000. But anyways, this is right. Making cabinet advice binding on the president. Yes, it is a 42nd Constitutional Amendment Act said that the president shall act in accordance with the aid and advice of the Council of Ministers. So this is also true. Allowing the president to send the cabinet advice once for reconsideration. That was by 44th Constitutional Amendment Act and not by the 42nd Constitutional Amendment Act 1978. So therefore this would be wrong. Which of the statements, which of the above is are part of the 42nd? It is 1 and 2 only. Come to the next question. Consider the following statements. The governor of a state has a constitutional discretion in appointing the ministers of the state cabinet. Is it true? In fact, the governor shall appoint the ministers only on the advice of the chief minister. And who is appointed as a chief minister? Does the governor has any discretion in appointing the chief minister? So generally he does not have any discretion. So don't talk about the exception. Generally he does not have any discretion. So who shall be appointed as a chief minister is only the leader of the single largest party, or the leader of the largest party, or the leader of the largest coalition. But if there is no party, no coalition which is having a majority, or not a single party is having a majority, then it is considered to be a hung assembly. In case of hung assembly, then the governor will have a discretion in appointing the chief minister. But otherwise generally he should not appoint anyone as a chief minister. But however, it is not given in the constitution. It is only a conventional practice that is followed in our country. Okay, so you should be very clear about all those things. So therefore, once a chief minister is appointed, then the other ministers are appointed only on the aid and advice of the chief minister. Okay, so this is definitely wrong. The governor of a state is appointed by the president by a warrant under his hand and seal. Is it true? Yes. The governor is appointed by a warrant under his hand and seal. Can you tell me some of the other authorities who are appointed by a warrant under their hand and seal? The judges of the Supreme Court, High Courts, and then the attorney. So not the attorney general, the comptroller and auditor general. So these are all some of the authorities where there is use of what is called as warrant under the hand and seal. Which of the statements given above are incorrect? One only. Consider the following statement. Statement 1. The governor as per the constitution should be an outsider and should not be a resident of that particular state where he or she is appointed as a governor. Is it true? So the key word here is as per the constitution. There is no such provision in the constitution. It is merely what? It is merely a recommendation that is given by which commission? Sarkaria Commission. What is the major recommendation that is given by the Punchi Commission in this regard? With regard to bringing in independence to the office of the governor? In fact, the Punchi Commission suggested that the word pleasure of the president shall be removed, that the governor occupies office during the pleasure of the president. Instead of that, what they said, how the governor shall be removed? A same manner as that of the president. That means the impeachment process which can be done by the state legislature. Okay. So this is not there in the constitution. The governor's salary can be diminished during his term of office by an act of parliament. The governor's salary cannot be diminished during his term of office. It cannot be varied to his disadvantage. Governor enjoys a fixed term under the constitution. Is it true? So if you read the constitution says that normally the tenure of governor is 5 years, but that is subject to the doctrine of pleasure of the president. So therefore, to say if you read combinedly these things, the constitution does not provide him what is called as a fixed tenure. Okay, so that's the understanding you should have. So the governor enjoys a fixed term under the constitution is wrong. So how many of the statements given above are correct? None of them is correct. Okay, so come to the next question. A member of parliament or state legislature cannot be appointed as a governor. Is it true? A member of parliament or a member of state legislature can be appointed as a governor. That is not an issue. Because what is the qualification for someone to be appointed as a governor? Should be a citizen of India and he should have completed 35 years of age. There is no other thing. A member of parliament or a member of state legislature can be appointed as a governor. But once a member of parliament or a member of state legislature is appointed as a governor, can they continue to be a governor and also member of parliament or state legislature? That is not possible, because one of the conditions of the office of the governor is that they should not hold on to any office of profit. And not only office of profit, this is not even office of profit, but it will create a conflict of interest between an executive post and a legislature post. So therefore, he should not hold on, he should not be a member of parliament or a state legislature once he is appointed. But at the time of appointing, he can be a member of parliament or a member of state legislature. To say cannot be appointed, it is wrong. The salary and other allowances of the governor is determined by the President of India. So who determines the salary and allowances? It is a parliament that determines the salary and allowances. But when the president comes into play with regard to the governor, when the same person is appointed as a governor for 2 or more states, in that case also the president does not determine the salary. It is only how the extra allowances shall be payable by different states. That order will be issued by the President of India. So what is the answer here? Which of the following are incorrect? So the answer is option C. So both are incorrect. Come to question number 161. Consider the following statements regarding the removal of the Vice President of India. He or she is removed by a resolution passed by special majority in both the houses of the parliament. Is it true? What is the majority with which the vice president has to be removed? By effective majority in Rajya Sabha and simple majority in Lok Sabha. But however, in which house the resolution shall be introduced? It can be introduced only in the Rajya Sabha, and before introducing that, what is the time duration the notice has to be given? 14 days of notice has to be given. So it has to be passed with what? Special majority. So special majority is wrong. So can anyone tell me what does it mean by effective majority? Majority of effective membership of the house. And what is effective membership? Total membership minus vacancies. Okay. The resolution for his or her removal can be introduced in either houses of the parliament. Can it be introduced? This year, this is a very important topic because as I already said, never ever in the history of India that they try to introduce a notice to remove the Vice President of India. So either houses is wrong. The resolution for his removal can be introduced only after giving 14 days of prior notice. Is that true? Yes, that is true. So how many of the statements given above are incorrect? It is 2 only. Okay. Consider the following statements. Repeated, huh? Okay, so okay, this is repeated. Okay. Okay, come to question number 163. Who of the following is a part of the Electoral College of the Vice President of India? Who is part of the Electoral College of the Vice President of India? Members of the Parliament. There is no distinction between elected and a nominated member. The members of the Parliament, because Electoral College itself was very restricted, they did not make any distinction in this regard. And moreover, the Vice President was not to perform any executive function. Normally, he is to act as the ex officio chairman of Rajya Sabha. But what about the Electoral College of the President of India? Elected members of both houses of parliament, elected members of legislative assemblies of the state, and the elected members of legislative assembly of Delhi and Puducherry. What about the elected members of legislative assembly of Jammu and Kashmir? Are they part of the electoral college? Presently, they are not part of the electoral college. What is the way by which they can become part of the electoral college? Either there should be an amendment to the constitution and they have to specifically insert the word Jammu and Kashmir as a part of the union territory, or the union territory of Jammu and Kashmir is converted into a state. That is the way that which they can become part of the electoral college. So what is the answer in this case? Elected members of parliament, yes. Vice President, elected members of the state legislature, no, it is not there. Nominated members of the parliament, yes. So the answer is 1 and 3 only. The President of India can be removed by a resolution passed by a special majority in both houses of the parliament. Which of the following correctly represents the special majority? Which special majority is required? Majority of not less than 2/3 of the total membership of the house. This is very important. So please do not make a mistake. Don't think that it is not less than 2/3 of the members present and voting. It is a total membership of the house. So therefore, how many are present in a given day is not important. So what is important is it should be passed by 2/3 of the total membership of the house. So in this case, where the notice can be introduced, it can be introduced in either of the houses. Here also 14 days prior notice to the president, and the president will have the right to defend in which house? Second house or in the first house? Why not in the first house? There is no need to defend it in the first house, because unless and until it is passed in the first house, the president does not have to do anything, because it has to go to the second house, then he will have the right to defend it. So the answer here is option C. How many times notice has been introduced to remove the President of India? We have no president in our constitutional history. Okay. So consider the following: proportional representation, single transfer voting system, open ballot. Which of the above mechanisms are associated with the system of presidential election in our country? So do we follow a system of proportional representation? Do you follow a system of single transfer voting system? And do you also follow a system of secret ballot? Yes, all the three things are part of the presidential, sorry, here it is open ballot is not there, but we follow what is called as secret ballot. So therefore this is not there, this and this is there. So what is the answer here? 1 and 2 only. So the right answer here is secret ballot. And because we follow what is called as a secret ballot, now the question is, will the anti-defection law applies in case of president election? The anti-defection law cannot apply because it is based on what is called as secret ballot system. Okay. So that's very important. Consider the following statements regarding the President of India. Statement 1. In case of vacancy to the office of the President, a new President must be elected within a period of 6 months in all cases. Okay, first of all, tell me, can anyone tell me what are the grounds on which the vacancy can arise to the office of the President? What are the possible grounds? One is vacancy because of the expiry of the term of the incumbent President, expiry of the term, then death, resignation, removal, or otherwise. Otherwise is what is given in the constitution. What does it mean by otherwise? Anything apart from these 4 things, which may be that the Supreme Court of India declares the election of the President to be unconstitutional or invalid. So in all these 5 grounds there can be vacancy. I am just repeating it again: expiry of the term of the incumbent President, because of the death of the incumbent President, resignation of the incumbent President, we can resign it to the Vice President of India, submit the resignation, or it can be because of what? Removal or otherwise. In all these cases there will be a vacancy. Now the question is, in case of vacancy to the office of the President, the new President must be elected within a period of 6 months in all the cases. Is it true? In case of vacancy, suppose if it is going to arise because of the expiry of the term, then the new President has to be elected even before the expiry of the incumbent President, even before the term is expiring. So therefore, to say it in all the cases, it is wrong. But if the vacancy is arising because of what? Death, resignation, removal, or otherwise, then within 6 months the new President has to be elected. So in the meantime, who will act as the President of India? It is the Vice President. Suppose if the new President is elected before the expiry of the term of the incumbent President, but the new President is not able to assume the office. So for example, the new President, before assuming the office, he met with an accident, a minor accident, so therefore he is hospitalized. So when on the day that the term is getting expiring for the incumbent President, the new President is not able to assume the office, then who will act as the President of India? Vice President or the outgoing President? The outgoing President would continue to be the President of India, and there is no time limit for this. Till the time the new President assumes the office, the outgoing President will continue to be in office. Okay, when the new President assumes the office, what will be his term? His term will be less than 5 years, or it will be a full 5-year term? Because already let us assume that the outgoing President is acting as a President for another 3 years, sorry 3 months, let us assume. So then the new President is assuming the office. So this new President will have a full 5-year term, okay, whenever he assumes the office. So therefore, to say in all the cases, it is wrong. Any election dispute regarding the election of the President can be challenged only in the Supreme Court of India. Is it true? Yes, only in the Supreme Court. This word only, exclusively, these are all very, very important, because 90% of the cases they are wrong. But in polity you cannot say it is always wrong, because there are certain areas where it can be right also. Okay, so you have to be very careful. So which of the statements given above are incorrect? It is one only. Consider the following statement: as per the conventional practice, the returning officer for the presidential election is usually the Secretary General, Lok Sabha or Rajya Sabha. Now this is not directly given in the constitution, this is as per the President, Vice President. It is as per the President, Vice President. Is it audible to the online students? Is it clear? So please give me confirmation. I guess it is audible to the online students. Okay. As per the convention, okay, so this is not directly given in the constitution, it is only mentioned in the President Vice President Election Act 1952. So if you see that the returning officer is someone who will preside over the entire election. So who is supposed to carry out the election of the President and the Vice President? Who is authority under the constitution to carry out the election for the President and Vice President? It is the Election Commission of India. And what is the responsibility of the Election Commission of India as per the constitution? What are all the areas they have to carry out the elections? To the President, to the Vice President, elections to the Parliament, and elections to the state legislature. When I say election to the Parliament, both to the Lok Sabha as well as Rajya Sabha. Election to the legislature means legislative assembly, and in case if a state is having legislative council also. These are the only 4 areas where they have to carry out the elections. And the only responsibility of the State Election Commission is to carry out election only to the local bodies. Now based on my experience, even after the students reading for 1 or 2 years, They are confused whether the state election commission will carry out the election to the state legislature or is it the election commission of India. So please make it very clear, it is the state election commission which will carry out elections only to the local bodies. Okay. Okay, now come here. So the constitution does not say that. So to some extent, okay, so did I say that it is mentioned in the President Vice President Election Act? Okay, it is not mentioned in the President Vice President Election Act, it is only a conventional practice. It is only a conventional practice that this has been followed, because there has to be someone who will preside over the election of the President and the Vice President. Okay. So as per the conventional practice, the returning officer of the President election is usually the Secretary General Lok Sabha, Rajya Sabha. This is true. Now who is the returning officer? Can anyone tell me? What is the role of this returning officer? Why it is called as returning officer? In the Lok Sabha elections also, it is called, they are called as returning officer. In the legislative assembly election also, they are called as returning officer. So of all the members who contest the election, only one person is declared certified as a returned candidate. That means he is a winner, the returned candidate. So therefore, who is supposed to certify that? The returning officer. So similarly, in the election to the President of India, there has to be someone who has to certify this. So normally, who is appointed as the returning officer by the Election Commission of India? It is either usually the Secretary General Lok Sabha or the Secretary General Rajya Sabha. Okay, so this is true. And the practice that is followed is it happens alternatively. So in the first year election, it is the Secretary General Lok Sabha, then it is Secretary General Rajya Sabha. Last election, I think it was the Secretary General Rajya Sabha. Okay, so anyways, you can verify that. So this is true. Anti-defection law applies in case of voting in presidential election. Is it true? No, anti-defection law does not apply. As per the presidential election rules, it is mandatory for an elector to give his all preferences at the time of voting. So you know that how the electors who are taking part in the election of the president, you can understand that there can be multiple candidates who will contest in the election. So therefore, unlike the elections, how we vote in the Lok Sabha elections and the legislative assembly elections, where we can vote to only one candidate, that is not the case in the presidential election. They can give multiple preferences. But is it mandatory for the elector to give preferences to all the candidates? That is not mandatory. But what is mandatory is that they have to give the first preference. If they do not give the first preference, then it becomes what is called as an invalid vote. Okay. And also, do you know how the Election Commission of India distinguishes between the electors when it comes to the presidential election? Do you know how they distinguish? Because there are MPs also, there are MLAs also, and different values has to be assigned to these votes. So different color voting card is given to different people. Okay. So I think to the members of the parliament, they give what is called as a green color, and to the members of the state legislature, a green color is given. Anyways, you just remember there are different colors that is given. Okay. So as per the presidential election rule, it is mandatory for an elector to give all the preferences. No, that is also not true. So what is the answer here? It is, how many of the statements are incorrect? It is 2 only. Consider the following statements regarding the President of India. So please come to the next question. The electoral college of the President includes members of both the houses of parliament, both elected and nominated. It includes only what? The elected members. So this is quite easy. A sitting member of parliament or a state legislature cannot contest to the office of the President. Can they contest? Please tell me. Can a sitting member of parliament and a state legislature, without resigning from being a member of parliament or a state legislature, can they contest? But you already read that one of the qualification to contest election to the office of the President is that they should not hold on to any office of profit. It is an exception. The exception is only to the, let me just read the question again. Okay. The exception is only to what? The exception to contest election of the office of the President is only for President, Vice President, governors and the ministers. So the members of the parliament or the members of the state legislature, you cannot say them to be ministers. Of course, not everyone cannot be a minister. If it is a minister, it would be mentioned as a minister. So therefore, just rethink on this. I am giving you one more time to think, and if at all you want, you can change your option, but you cannot do that in UPSC. So therefore, you have to be very clear when you do the answer in UPSC. So my question is, can a sitting member of parliament or a sitting member of state legislature, can they contest to the office of the president without resigning from being a member of parliament or member of state legislature? Yes or no? Yes, because a sitting member of parliament or a sitting member of state legislature is not an office of profit. I have already made it clear to my students, but if somebody who is new to the class, you should be very clear that a sitting member of parliament or a sitting member of state legislature would not be considered to be an office of profit. Why it is not an office of profit? Because office of profit is majorly an executive post. That is, either it is an office under the central government, state government or the local authorities, by a way of which a profit is receivable. But whereas a sitting member of parliament or a sitting member of state legislature, are they part of executives? They do draw a salary. I am not saying they are not drawing a salary, but they are part of the legislature. So therefore, they will not qualify as what is called as an office of profit. But if a sitting member of parliament or a sitting member of state legislature, if they contest election to the office of the president, for which they do not have to resign, but once they get elected as the president, then they automatically cease to be a member of parliament or a member of state legislature. Okay, is that clear? So that's a condition under the office of the president. So therefore, a sitting member of parliament or a state legislature cannot contest election is a wrong thing. They can contest election. The emoluments and allowances of the president are determined by an act of parliament. Is it true? Yes, for the president, the emoluments and allowances are determined only by the parliament, not by any of the other authority. So what is the answer here? Which of the statements given above are incorrect? So what is the answer? 2 only. Okay, so come to the next thing. Consider the following statement as per the Constitution of India. The notification to the election of new president must be issued by the Election Commission of India anytime 60 days prior to the expiry of the outgoing president. Is it true? This statement is true, but not as per the Constitution of India. Okay, so the question is, consider the following statement as per the Constitution of India. The Constitution does not say this. It is only as per the President Vice President Election Act. Okay, so therefore, while it is factually true, but it is not as per the Constitution. It is only as per the President Vice President Election Act. So therefore, this particular statement is wrong. The nomination paper of a candidate for the election to the office of the president to be accepted by the returning officer requires it to be subscribed by 50 electors as proposers and 50 electors as seconders. Is it true? The nomination for the candidate, so this is again true, but not as per the Constitution. This is again, it is a rule under the President Vice President Election Act. Okay, so this is also, the statement per se is true, but not in the Constitution of India. The Constitution of India provides only certain qualifications, that he should be a citizen of India, completed 35 years of age, should not hold on to any office of profit, subscribe to an oath in front of the authority as appointed by the Election Commission of India. So some qualification is there in the Constitution, but these are all additional qualifications by way of the President Vice President Election Act. Which of the statements given above are correct? It is neither one nor two. Suppose instead of the Constitution, then that would be a right thing. With reference to the election of the President of India, consider the following statements. The value of vote of each MLA varies from state to state. Does it vary? Yes, of course it will vary. There is no doubt. It varies from state to state. The value of vote of MPs in the Lok Sabha is more than the value of vote of MPs in the Rajya Sabha. Is it true? It is false. Their value is the same, because there is only one formula for the value of vote of MPs. Can anyone tell me what is the formula to calculate the value of vote of MPs? Total value of all valid votes divided by 2 plus 1. Okay, so this is a, so sorry, this is electoral quota. Okay, just let me just correct it. Total value of all the, by not the MLAs. So this is total value of valid votes of all the MLAs, of all MLAs from all the states and union territories divided by elected MPs. And what is that elected MPs? It is 543 plus 230, no, 233. Okay, so that's the number of elected MLAs, sorry, MPs. So that means it is 776. So this is the value of the MPs. It is not 238 because right now in Rajya Sabha how many MPs are there? Only 245. Although the total authorized strength is 250, but presently there are only 245, of which 12 are nominated members. So therefore it is only 233. So what is the answer here? Which of the statements are correct? So therefore the answer is 1 only. Okay, so come to the next question. As per the Constitution of India, the governor or the ex officio, this is part of your current affairs. Okay, so I put this question because it is very much related to the current affairs. So what is the issue right now is many of the states have passed a bill where they wanted to replace the governor as the chancellor of the state universities, but none of the governor have given assent to this bill. So because they are giving assent to a bill where somebody else will replace him as the chancellor. So many of the governors are sitting on this particular bill. So there is a lot of news that is coming, should the governor continue to be the chancellor of the state universities. So to that extent, tell me, as per the Constitution of India, the governor or the ex officio chancellor of state universities, is it true? Is it true or false? This is not a constitutional position that is given to the governor, it is only a statutory position. Many laws enacted even before India became independent by the British Parliament, which has made the governors of the state to be the chancellors. So at that point of time, you had governors for the provinces, so they were made as the chancellors of the state universities. So that is even continuing today. So many states wanted to replace this position, so they have enacted already a bill and they have sent it to the governor, where the governor is not giving the assent. But anyways, that is not in the constitution, it is only based on a statute. So this is wrong. The Punchi Commission on Center-State Relationship recommended appointment of an eminent academician as Chancellor of State Universities. What about this? Does anyone know? Punchi Commission was a commission which is related to center-state relationship. They also understood that the position of governor should become independent, and they also thought that the governor is unnecessarily occupying certain powers and position. So Punchi Commission made this recommendation. They wanted an eminent academician to become the chancellor. That makes sense also, because not all the governors may be an eminent academician. So therefore that is a recommendation that was given by the Punchi Commission. So this is true factually. So what is the answer? Which of the statements given above are correct? It is 2 only. Which of the following article deals with the power of the governor in relation to the bills presented for his or her assent? 200 or 201? 200, sure. So what is there in article 201? When the bill is reserved for the consideration of the president, then what are the options that can be exercised by the president of India under article 201? Okay, I yesterday discussed what are the options in the hands of the governor. What are the options in the hands of the governor? Very quickly, he can give the assent, or he can, what he can do, he can withhold the assent, or send it for reconsideration, or he can reserve it for the consideration of the president. Okay, so these are the options that he can exercise. But recently the Supreme Court has made it very clear, he can give the assent, he can withhold the assent, he can send it for reconsideration, and he can also reserve it for the consideration of the president. But if he is directly withholding the assent, then as soon as possible he has to send it for reconsideration. And if the state legislature is again passing it, then the governor has to give the assent. So this is what the Supreme Court has said. But however, what is that as soon as possible? What is the reasonable time limit within which he has to send? That is not given in the judgment. Okay, now when he is reserving it for the consideration of the president, now then the fate of the bill will be decided only by the President of India. Now then article 201 will come into existence. So as per article 201 of the Constitution, what are the various options that the president can exercise? So what he can do is that he can give the assent. What he can do? He can withhold the assent, or he can send it back for reconsideration. Okay, so when he send it for reconsideration, what will happen? When he sends it for reconsideration to the state legislature, then the state has to again send the bill back to the president within a period of 6 months, and in this case it is not binding upon the president to give the assent. Okay, so this is what you will have to understand. But whatever the decision that he takes under article 201, the president is going to act as per the aid and advice of the Union Council of Ministers. Okay, so that is also very important. What is article 111 of the constitution is related to? Power of the president to give assent to the bills passed by the parliament. Okay, so please come to the next question. Consider the following statements. As per the constitution, shall I proceed? Okay. So consider the following statement. As per the constitution, a person who has held the office of the president is not eligible for re-election. So there is no restriction as to how many terms one can be a president of India. But however, we do not have a president except for Dr. Rajendra Prasad, who has been president twice. We don't have any other president apart from that, but constitutionally there is no such restriction. As per the constitution, a person who has held the president office is not eligible to re-election is a wrong thing. One of the condition to the office of the president as per the constitution is he or she should not hold any office of profit. Is it true? Office of profit is also one of the qualification to contest election, and office of profit is also one of the condition for the president office. So how many of you are clear as to what is the difference between qualification and condition? Is that clear? So qualification means these are all the qualification one has to possess to contest election. Condition of president office means once somebody gets elected, then also they have to fulfill certain constitutional conditions to continue in that particular office. So in both the cases, be it to contest election or after winning the election, in both the cases the president should not hold on to any office of profit. So where is this office of profit defined in the constitution? Is it defined in the constitution? It is nowhere defined in the constitution. It is only an interpretation that is given by the Supreme Court of India. So what is considered to be an office of profit? Any office either under the center, state or any of the other local authorities by way of which a profit is receivable. It is not mandatory whether the profit is received or not, but what should be seen is whether the profit is receivable in the first place. Or to put it in a very simple way, suppose let us assume a government post is there and somebody occupying that government post and not taking the salary. So therefore, can he say that he is not holding on to any office of profit? Whether the individual takes a salary or not, that is immaterial. But if the office provides for the salary in the first place, that itself is sufficient enough to consider that particular office to be office of profit. Okay. So therefore, one of the condition of the office of the president as per the constitution is he or she should not hold on to office of profit. So this is definitely true. So which of the statements given above are correct? Two only. Who among the following shall administer the oath to the governor before assuming the office? This is as per the constitution. Who is supposed to administer the oath? Okay, let us see. The Chief Justice of the concerned High Court. Is he supposed to administer the oath? Okay. So come to the second statement. In the absence of the Chief Justice of the concerned High Court, then the senior most judge of the court available. Is that true? Is it mentioned in the constitution? Of course, it is mentioned in the constitution. Okay, the constitution says that the administration of that oath has to be administered by whom? The Chief Justice of the concerned High Court. And in the absence of the Chief Justice, then who will administer the oath? The senior most judge in the particular High Court. So this is also true. The President of India, no, the President will not administer the oath. The Speaker of the Legislative Assembly. So which of the statements given above are correct? So the answer is 2 only. So both the statement 1 and 2 are correct. So this is the answer for this particular question. Okay. So come to the last question as a part of the executives. Consider the following statements. The number of ministers in the state shall not exceed 15% of the total members of the Legislative Assembly in all cases. Is it true? Here the key word is in all cases. So it's an extreme statement. So whenever an extreme statement is given, you have to be very careful about that. So is it true? It is not in all the cases, because what is the exception that you already learned? If the 15% of the total members of the legislative assembly is less than 12, then minimum there has to be 12 ministers. So therefore it is not possible in all the cases. So whenever they are trying to put a statement like this in all cases, then in that particular case you will have to think about the exceptions. Otherwise there is no need to think about the exceptions. So therefore this particular statement is wrong. As per the constitution, the council of ministers shall be collectively responsible to the state legislature. Is it true? As per the constitution, the council of ministers shall be collectively responsible to the legislative assembly, not to the state legislature. So in case of parliament, the word parliament would be wrong. They are collectively responsible only to the Lok Sabha. So here similarly they are collectively responsible only to the state legislative assembly and not the state legislature, because the word state legislature will also include what? The legislative council also. Okay. So therefore this is not the right thing. So which of the statements given above are correct? Which of the statements are correct? Sorry, it is neither 1 nor 2. Option D is the right answer. Can anyone tell me what is question number 168? What is the answer that you are given for 168? Is there any confusion in that question? What is that question? Some student is asking it out in the online. Okay, I am just repeating that question. The electoral college of the president includes members of both the houses of the parliament, both elected and nominated. So statement 1 is wrong, because it includes only the elected members. A sitting member of parliament or a state legislature cannot contest election to the office of the president. Can a sitting member of parliament or state legislature contest election? Yes, they can contest election, because the statement is saying cannot contest election, so therefore it is wrong. Statement 2 is also wrong. The emoluments and allowances of the president is determined by an act of parliament, so that is true. So how many of the statements are incorrect? So incorrect would be 2 only. So 1 and 2 are incorrect. Okay, so when I say MPs, so there was one question, the total value of MPs, that apostrophe is, that is not the cumulative value of all the MPs, it is only for one MP. So don't get confused. If at all UPSC wanted to check that the value of the cumulative value of MPs in Lok Sabha is more than the value of MPs in the Rajya Sabha, then that is right. So if they put apostrophe S, it is only a single value. Okay, so don't get confused in that regard. All right, shall we move to the next part, that is the legislature part? Can I have a better response? Okay, so we'll move to the next part, very important part. Okay, so minimum 4 to 5 questions is what is in the UPSC trend, and there are few areas where UPSC repeatedly asking question. So taking note of that, I have put a lot of questions, especially the constitutional amendment bills, the money bills, financial bills. So certain areas are there, so we'll try to see all those areas. Okay. Okay, so come to the first question in the parliament. Look into the question, which of the following is responsible for the preparation and presentation of union budget to the parliament? So whose responsibility is this? Although it is not there in the constitution, it is based on the transaction of business rules. Okay, tell me, as per the constitution, who is supposed to lay down the budget? President or the finance minister or the prime minister? It is the president who is supposed to lay down the annual financial statement. So if they ask as per the constitution, it is only the president of India. But we know that the prime minister or any of the other union council of minister is a subordinate of the president. So if you look into the constitution also says the president is head of the union executive and he can perform the functions of union executive on his own or through his subordinates. So therefore it is based on the transaction of business rules, it has been given to the union finance minister to present the budget. but as per the constitution who is supposed to do that is the President of India. So who will help out the Union Finance Minister in presenting the budget is the Department of Economic Affairs, and within the Department of Economic Affairs it is a budget division. So if you organize a ministry, the lowest level is the division, after the division it is a department, and then you have a ministry. Okay, so it is budget division, Department of Economic Affairs, Ministry of Finance. So what is the answer here? It is the Department of Economic Affairs. So the Department of Economic Affairs itself is headed by a secretary level officer. Okay. Okay, consider the following statements. The Constitution of India provides the Legislative Assembly of each state shall consist of not more than 450 members chosen by a direct election from territorial constituency in that particular state. Is it true or false? As per the constitution, what is the range when it comes to the state legislative assembly? It shall not be less than 60 and more than 500. So the range is between 60 to 500 and it is not 450. So with regard to the number it is wrong, but with regard to the principle it is right. So all the members shall be elected by a territorial constituency election. But however, this statement is factually wrong. It is 60 to 500. But is there any exception to this number of 60 to 500? There are certain exceptions that is given in the constitution. Say for example, Sikkim is an exception, and certain other northeastern states also there are some exceptions. Subject to the exceptions, so generally it is what? It is 60 to 500. Suppose if the question comes as per the constitution in all the states it should be 60 to 500, then it is wrong. But if it is not saying all the cases, then that should be a right statement. So therefore this particular statement is wrong. A person shall not be qualified to be chosen to fill the seat in the legislative assembly of a state if he or she is less than 25 years of age. Is it true? Yes, one of the qualification for someone to contest election to the Lok Sabha or to the legislative assembly is he or she should not be less than 25 years of age. In addition to that, they should be a citizen of India. They have to subscribe to an oath in front of an authorized authority, and apart from that they should be an elector from any constituency in India in case of Lok Sabha elections. What about in case of the legislative assembly elections? They should be an elector from any constituency in that particular state. Okay, that is very important. Now tell me this, there should be an elector from any constituency in that particular state or anywhere in India in case of Lok Sabha. Is this a qualification that is mentioned in the constitution? Is it a qualification which is prescribed in the constitution or not? This is not a qualification prescribed in the constitution, it is based on the Representation of People Act. Okay, so just try to keep this in your mind. So if a person is not qualified to be chosen to fill the seat in the legislative assembly of a state, if he or she is less than 25 years of age, so this is true. But it is asking the Constitution of India. Okay, this is provided in the constitution. So this particular statement is true. Which of the statements given above are correct? Two only. This is again a factual question. Sometimes it was asked in previous year questions also in UPSC. Who was a speaker of the first Lok Sabha? When was the first Lok Sabha came into existence? 1952. Before that it was only the Constituent Assembly that considered to be a provisional parliament. So but the first Lok Sabha came into existence only in 1952, and who was the first speaker? It was G.V. Mavlankar. And what is the majority with which speaker has to be elected? Simple majority or special majority? The only qualification that is given in the constitution for someone to be elected as a speaker, what is the qualification? That's the only qualification. He should be a member of that particular house. Only a member of that particular house can contest election to become the speaker, and the speaker is elected by simple majority. Not necessarily the elections may happen, not necessarily every time the elections may happen. Most of the times the elections will not happen because somebody will have a clear majority. So therefore if the ruling party nominates someone as a speaker, as a candidate, and if there is no opposition, then he will be unopposed, elected. So but if the election happens, then he has to be elected by what is called as simple majority. This is very, very important. And who conducts the election of the speaker? Who will conduct the election of the speaker? It will be conducted by the speaker pro tem. So who will appoint the speaker pro tem? It is a president who will appoint the speaker pro tem, And who shall be appointed as a speaker pro tem as per the constitution? Let me complete the question. So that is why you should always read the question fully in UPSC. You should always listen to the question in the interview most importantly. So don't jump into conclusions. So that's a very bad thing because you tend to make a lot of mistakes. So listen carefully. So as per the constitution, who is supposed to be appointed as a speaker pro tem? Nothing is given in the constitution. It is only a conventional practice that the senior most member in the Lok Sabha is appointed as a speaker pro tem by the President of India. Okay. Okay, once a speaker pro tem conducts election, once a speaker is elected, then the office of the speaker pro tem ceases to exist. Who will decide the date of election of the speaker? It is a president who will decide the date of election of the speaker. Is that clear to all of you? So the answer is option B in this case. Okay, come to the next question. With reference to the Indian public finance, consider the following statements. Statement 1, the disbursement from the public accounts of India are subject to the vote of parliament. Is it true? In fact, what are the funds that is mentioned in the constitution? What are the different funds that is mentioned in the constitution? One is the consolidated fund of India, the most important fund. You have public accounts of India and then the contingency fund. Okay, now all these funds are mentioned in the constitution, but is all the three funds established by the constitution directly? So how many of you think that yes, all the three funds are established by the constitution directly? That is, in case of the union, that is the consolidated fund of India, the public accounts of India and the contingency fund of India. Are they directly established by the constitution? How many of you think yes? Okay. So not all the three funds are directly established by the constitution. Though it is mentioned in the constitution, there are only two funds which is directly established by the constitution. What are the funds? It is only the consolidated fund of India and the public accounts of India. When it comes to the contingency fund of India under Article 267 of the constitution is only empowering the parliament to make a law, and by that law they can establish. So not necessarily it will come into existence unless and until the parliament enacts a law. So therefore today do we have a contingency fund of India? Yes, because the parliament has enacted the Contingency Fund of India Act 1951, and by which the Contingency Fund of India Act is established. So therefore if a question comes, how many of the funds are established by the Constitution of India, what is the answer? Now why I am discussing this is, there is a previous year question where they have asked this. So only two funds are established directly. What are the two funds? Consolidated fund and the public accounts of India, and not the contingency fund. But if the question is, if it is mentioned in the constitution, yes, it is mentioned, but it is not directly established by the Constitution of India. So anyways, with that you just come to this particular question. The disbursement of the public accounts of India from the public accounts of India are subject to the vote of parliament. Is it subject to vote of parliament? Only in one case it is subject to vote of parliament. If they are going to appropriate money from where? If they are going to take out money from the consolidated fund of India. Because the constitution very clearly says that not even a single rupee can be taken out of the consolidated fund of India except for an appropriation bill passed by the parliament. What about taking out money from the public accounts of India? It does not require the approval of the parliament. It is at the disposal of the executives. So the executives can pass the order, and through which the money can be taken out. And what about the contingency fund of India? It is at the disposal of the President of India, and the President has delegated this power to the Secretary Ministry of Finance. He can delegate it to some other authority also. So therefore, to take out money from which fund, it requires approval of the parliament? Only the consolidated fund. And what are the money that belong to these funds? I will subsequently discuss. There are questions coming, I will discuss at that particular time. Okay. So therefore, with that come to this particular question. The disbursement from public accounts are subject to vote of parliament? Definitely not true. The Indian constitution provides for the establishment of consolidated fund, public accounts and the contingency fund for each, for India and for each state as well, if you see that. So the Indian constitution provides for establishment of a consolidated fund for the state, public account for the state, but not for the contingency fund for each state. Even for the state also, the contingency fund can be established based on the law that is passed by the concerned state legislature. So it is not directly established by the constitution. So therefore this particular statement is wrong. So which of the statements given above are correct? It is neither one nor two. Okay, which article in the constitution provides for the consolidated fund of India and the consolidated fund of states? Article 2. Article 266 provides for 4 funds. What are the 4 funds? Article 266 provides for 4 funds, not 2 funds. Consolidated fund of India and the consolidated fund of states, public accounts of India and the public accounts of the states. Now these are all directly established by the constitution. And the Article 267 provides for 2 funds but not directly established by the constitution. It provides for contingency fund of India, which can be established by an act of parliament in case of union. It also provides for contingency fund for every state, provided the law made by the concerned state legislature establishes them. Okay, please come to the next question. Consider the following statements. The Speaker of Lok Sabha has a power to adjourn the House sine die, but on prorogation, it is only the President who can summon the House. The Speaker of the Lok Sabha has a power to adjourn the House sine die, but on prorogation, it is only the President who can summon the House. Is it true? So first of all, tell me what is adjourn sine die and what is prorogation? What is adjourn sine die? Can anyone tell me? Adjourn sine die means basically the House is still in session, but the House does not actively perform any function because the presiding officer has adjourn sine die, which means that he has given an indefinite break. It is not a definite break. What is a definite break in the House? Adjournment is a definite break. Adjournment means whenever the House is adjourned, the session is still intact, but when the session is adjourned, when the House is adjourned, that means the presiding officer is saying when the House will meet again. Adjournment can be for hours, it can be for days, it can be for weeks, but it is something which is very definite. But when the presiding officer is saying that I am adjourning the House without saying when the House will meet again, then he is adjourned sine die, that is adjournment sine die. So who can adjourn and adjourn sine die the House? The presiding officers. So once the House is adjourned sine die, then the President will prorogue the House, because then the President knows that all the function in the House is over for the session, and then the President will prorogue the House. What is prorogation? Prorogation means terminating the House, terminating the session. Now once a session is terminated, then again who can summon the House? Only the President can summon the House. So therefore this particular statement is correct. Unless sooner dissolved or there is an extension of the term, there is an automatic dissolution of the Lok Sabha by the efflux of time. Efflux of time means the time is over at the end of the period of 5 years, even if no formal order or dissolution is issued by the President of India. So now before I answer this particular question, unless sooner dissolved, is it possible to dissolve the Lok Sabha sooner? Yes. What is the ground on which it can be dissolved? When there is a no confidence motion, or even when the Council of Ministers themselves advise to dissolve the House earlier. Okay, unless sooner dissolved, or there is an extension to the term of Lok Sabha. Can there be an extension to the term of Lok Sabha? What is the ground on which it can be extended? Only when there is a national emergency. And who is the authority to extend the term of Lok Sabha? Parliament or the President? It is a Parliament who is authority. The Parliament by a law, they can extend the term of Lok Sabha indefinitely, but however 1 year at a time. So every year they can pass a law and they can extend the term of Lok Sabha. So unless until it is sooner dissolved or extended by the Parliament because of the national emergency, there is an automatic dissolution. So this is very much true. The Lok Sabha automatically gets dissolved. So not necessarily every time the President has to pass a formal order, because who is supposed to dissolve? It is the President of India, but it is not necessary for him to do. Once the time is over, automatically the President will, automatically the House will dissolve. When the president will pass an formal order is only when the ministers fail to submit the resignation. If they fail to submit the resignation, then the president will pass an order and he will dissolve the Lok Sabha. Otherwise, it will happen automatically. And by parliamentary convention, whenever the time is over, the government automatically submits the resignation and there is an automatic dissolution. And at that point of time, the government, once the Lok Sabha is dissolved and the minister submits the resignation, will there be a prime minister and the council of ministers for our country? Yes or no? Yes. They already submitted the resignation, then how they can continue to be a prime minister or a council of minister? They would still be the prime minister and the council of minister, but in caretaker capacity. Because what the constitution says, that the president shall always act in accordance with the aid and advice of the council of ministers. So therefore, the prime minister and the council of ministers would continue to exist, but in what is called as a caretaker capacity. So what does it mean by caretaker capacity? So when they are acting as a caretaker government, they cannot give any new policy advice. Whatever is already in place, with regard to that, the advice can be given. No new bills, no new policies, nothing can be done by a caretaker government. Okay. So this is true. The Speaker of Lok Sabha continues in office even after the dissolution of the Lok Sabha until immediately before the first meeting of the House. Is it true? This is also true, because it is also very important, the term of the Speaker is not coterminous with the term of the House. That means even after the Lok Sabha is dissolved, the Speaker would continue to exist, because once the Lok Sabha first sitting or the first session come into existence, you do not have a Speaker, because who is appointed as a Speaker at that point of time? It is only the Speaker pro tem by the President, and then the elections has to happen, then the new Speaker will be elected. So the Speaker would continue to exist even after the dissolution of Lok Sabha, till the time in the new Lok Sabha somebody is appointed as a Speaker pro tem. Once a Speaker pro tem is appointed, then the Speaker ceases to exist. Okay. So what is the answer here for this particular question? It is 1, 2 and 3. All the 3 things are the right answer. Which of the following statement is correct? Statement 1. In Lok Sabha, the no confidence motion has to set out the grounds on which it is based. First of all, tell me, where is this no confidence motion mentioned? Where is it mentioned? It is mentioned in the rules of the House. Very good. It is not mentioned in the constitution. So if you see, the constitution only says that the council of ministers shall be collectively responsible to the Lok Sabha. So therefore, there should be a way to check the responsibility of the ministers to the Lok Sabha, and therefore accordingly the Lok Sabha has made a rule. It is in rule number 198 of the Lok Sabha. So as per rule number 198 of the Lok Sabha, any member of parliament can introduce a notice to check whether the government is having the majority or not. But however, as per this particular rule, there is no need to specify the reason as to why they wanted to introduce a no confidence motion. And this is one motion, they can discuss anything. But in the other motions, if you see, specifically they have to state the reasons as to why they wanted to introduce this, but there is no such reason that is required when it comes to what is called as no confidence motion. So in Lok Sabha, the no confidence motion has to be set out on the grounds on which it is based, so definitely it is not true. There are also other things that I have to discuss about the no confidence motion, but there is a specific question that is coming. I will discuss about that. So right now we introduce, you remember that there is no need for any ground or reason to introduce the no confidence motion. In the case of a no confidence motion in the Lok Sabha, no conditions of admissibility have been laid down in the rules. What about this? Is there any conditions for admissibility of this particular notice? Of course, there are conditions. Of course, there is no need to specify the reason, but there are conditions. Say for example, before this notice can be admitted by the Speaker in case of Lok Sabha, it has to be minimum supported by 50 members in the Lok Sabha. So therefore, there are conditions for its admissibility into the House. So therefore, this is wrong. The Rajya Sabha is not empowered to entertain the motion of no confidence. Is it true? Yes. The Rajya Sabha cannot entertain, because as per the rules of the House, in which House a no confidence motion can be introduced? Only in the Lok Sabha, not in the Rajya Sabha, and that is in line with the constitutional principle, because the council of ministers shall be accountable or collectively responsible only to the Lok Sabha and not to the Rajya Sabha. So what is the answer here? So anyway, C is the correct answer. Come to the next question. which of the, consider the following statements. While the members of the Rajya Sabha are associated with the committees on public accounts, public undertakings, public accounts committee and the committee on public undertakings, the members of committee on estimates are drawn entirely from the Lok Sabha. Is it true? Okay, before we see whether these things are true, most of the year there is one question from the parliamentary committees. So therefore, this area is a very, very important area. We will try to revise everything through the questions. Okay, I will discuss this question and I will see some online doubts are there. Okay, so come to this particular question of these three committees. There is one similarity between all the three committees. What is the similarity? All the three committees are considered to be the financial committees of the parliament. Okay, so if at all a question comes, which of the following are the financial committees? There are only three financial committees, and all these three committees are also permanent committees in the parliament. So there are two similarities. One is they are all financial committees and they are all permanent committees. Okay, but there are differences. Coming to the differences, when you come to the Public Accounts Committee and the Committee on Public Sector Undertaking, in both these committees there is representation from both Lok Sabha as well as Rajya Sabha. And what is the membership of the Public Accounts Committee and the Committee on Public Sector Undertaking? Both have got 22 members, and out of which in both the cases 15 members from Lok Sabha and 7 members from Rajya Sabha. And in both the cases, whether the members are elected or nominated. Think about it one more time, whether elected or nominated. They are elected, and they are elected by a principle of proportional representation. So that means the representation in these committees will be proportional to the members from different party in the house. So therefore, who is likely to have more members in these committees? Of course, the party that is there in power, so or the coalition which is there in power, because it is all based on proportional representation. So 15 members from Lok Sabha, 7 members from Rajya Sabha. In both the cases, they are all elected, and usually their term is for a period of 1 year. Can they again get re-elected? Is it possible? Mostly the same member is again will get re-elected to the particular thing. And one thing that you have to remember is, when it comes to the Public Accounts Committee, the chairperson of this Public Accounts Committee as well as the chairperson of the Committee on Public Sector Undertaking, they are nominated among the members elected from the houses. So usually the chairperson of the Public Accounts Committee is from the Lok Sabha, and who appoints someone as a chairperson? The Speaker Lok Sabha will appoint the chairperson, and as per the conventional practice, not in the constitution, as per the conventional practice, usually an opposition member is appointed as the chairperson of the Public Accounts Committee. In the last class also I asked this question, I think. Who is the chairperson of the Public Accounts Committee? Mr. K.C. Venugopal of the Congress party. So he is the chairperson presently. But however, there is no such conventional practice in case of the Committee on Public Sector Undertaking. So there usually the chairperson is again appointed by the speaker, but from the ruling party. So this is with regard to these two committees. But however, in case of Estimates Committee, there are only members from the Lok Sabha. And how many members are there in this particular committee? 30 members. All the 30 members are only from the Lok Sabha. And all the members are again elected by proportional representation, and the speaker will nominate one person as the chairperson of this particular committee as well. So this is what you should know. So whether the statement is true or false? While the members of Rajya Sabha are associated with the committees on public accounts and public undertakings, the members of Committee on Estimates are drawn entirely from the Lok Sabha. Yes, this is true. The Ministry of Parliamentary Affairs work under the overall direction of Cabinet Committee on Parliamentary Affairs. So we have seen different cabinet committees. So we have different cabinet committees. So what are these cabinet committees? Who comprises cabinet committees? The cabinet ministers. So normally, if you see, do you know what is the main role of the Ministry of Parliamentary Affairs? The Ministry of Parliamentary Affairs is to see the government agenda in the parliament. what type of bills they wanted to introduce, what kind of discussions they wanted to have. So everything will be decided by for the government by the Ministry of Parliamentary Affairs. So it is looking into one of an important agenda of the government in the parliament. So therefore, who will guide the Ministry of Parliamentary Affairs in this particular regard? The decision will be taken by what is called as a Union Cabinet on Parliamentary Affairs, because we follow what is called as a cabinet system. It is not that the major decisions of the government is taken by an individual minister, but who will take the major decisions of the government? A cabinet committee related to a particular matter. So therefore, this particular statement is true. The Ministry of Parliamentary Affairs works under the overall directions of the Cabinet Committee on Parliamentary Affairs. So this Cabinet Committee on Parliamentary Affairs means it's an executive body. It will comprise of the Union Cabinet Ministers. It will definitely consist. It is headed by the Prime Minister, or the Prime Minister can allow somebody else to head it also, maybe by the Home Minister also, and it will contain other cabinet ministers also as a part of it. So they will decide with regard to what they have to do in the parliament. Come to statement number 3. The Minister of Parliamentary Affairs nominates members of the parliament on committees, councils, boards and commissions etc. set up by the Government of India in the various ministries. Just think about this particular statement for a moment. See, what happens is, sometimes the government, for better analysis, even it is a government decision to take, they may nominate some of the members of the parliament to give some suggestions on that particular matter. So in that particular case, if at all the government wanted to nominate some of the members of the parliament to various government boards, government councils, so in that particular case, who will decide as which member of parliament shall be appointed to all those things? Is it the Minister of Parliamentary Affairs? That's the question. So this is nowhere given in the constitution, but as per the transaction of business rules, it is the responsibility of the Ministry of Parliamentary Affairs to do that. Okay, it is the Minister of Parliamentary Affairs who will do that. So this is also true. So which of the statements given above are correct? The correct answer is 1, 2, 1, 3 only. Is that clear to all of you? What is question number 177? Can anyone tell me what is question number 177? What is the doubt there? Can anyone give me the copy? Okay, question number 177. The Legislative Assembly of each state shall consist of not more than 450 members and chosen by direct election from the territorial constituencies of each state. What about this particular statement? It is clearly wrong, because the Legislative Assembly of each state shall not consist more than 500 members and not 450. So therefore, that is clearly wrong. Second statement, a person shall not be qualified to be chosen to fill the seat in the Legislative Assembly of a state if he or she is less than 25 years of age. This is also clearly given in the constitution. So this particular statement is true. So which of the statement given above are true? It is option B only. Okay, so there is no doubt. So option B is the right answer. Guruprit Kaur, you have asked a question, but I do not know what is your question. You can just post your question once again. So just you also revise, just give me a couple of minutes. I will just attend to some of the doubts of the online students. Okay, all right. I think we are good to go. There is no other questions. Guruprit Kaur, you can just put your question, because I could not see your question. No, the age criteria is directly there in the constitution. So please look into that particular question. The age criteria, not less than 25 years of age and not less than 30 years of age for the Rajya Sabha, is directly given in the constitution itself. All right, shall we move forward? Shall we move forward? Okay. Okay, so come to the next question. Which one of the following bills must be passed by each house of Indian Parliament separately by a special majority? What is the answer? Ordinary bill, what is the majority that is required? Has it to be separately passed in all the cases? When the question stresses upon passed separately by special majority, that means there is no other way, only separately it has to be passed. What about the ordinary bill? Is it mandatory it has to be passed separately? There are exceptions to that. What is the exception? It can be passed by a joint sitting. So in the entire political history of India, how many times a joint sitting has happened? 3 times it has happened in the entire history of India. Okay, so therefore not necessarily in all the cases it has to be passed with separately, and anyways in this case it is only a simple majority. Money bill, what is the majority that it is required? Simple majority. Has it to be separately passed? It has to be separately passed, but unfortunately for the Rajya Sabha they cannot do anything about it. They can delay it only by a maximum of 14 days. There is no possibility of joint sitting here also. What about the finance bill? It has to be passed with simple majority. So here also it is almost similar to that of the ordinary bill, but anyways it is passed with simple majority. So what is the answer? Constitutional amendment bill. That means you should have an understanding. In case of a constitutional amendment bill, there is no provision for joint sitting. It has to be separately passed by both the houses of the parliament. So therefore my students are asking me, what if the Rajya Sabha is not accepting? Because if the government is not having the majority, what if the Rajya Sabha is not accepting for a constitutional amendment bill? So does there any alternative? No way. Only when the Rajya Sabha passes it, then only they can get it done. That is why recently Mr. Shashi Tharoor, when he was giving one of the speech, the government was so adamant on introducing a constitutional amendment bill with regard to bringing what is called as simultaneous elections. So therefore Mr. Shashi Tharoor said that anyways you don't have the majority in the Rajya Sabha, so you don't even have the simple majority, but you need a special majority in the Rajya Sabha to get this simultaneous elections bill passed, because for the simultaneous election you need to make amendment to the constitution also. So therefore in this regard it is also related to the current affairs. So which is the only case which requires a special majority in both the cases? Separately it is a constitutional amendment bill. Okay, so this is the answer. Which one of the following statement is correct? Statement 1. Okay, here there is a small correction. I will just make a small correction here. With that you read it. Both in the Rajya Sabha and the Lok Sabha, both in the Lok Sabha and Rajya Sabha, both not the Lok Sabha can have nominated members. 1 minute, 1 minute. Both Rajya Sabha and the Lok Sabha. Okay, so both Lok Sabha and the Rajya Sabha, sorry, both Rajya Sabha and the Lok Sabha, and not the Lok Sabha alone. So just make it small correction here. So both Rajya Sabha and the Lok Sabha, and not the Lok Sabha alone can have nominated members. Is this statement true? Is the statement true or false? Anyways, the Lok Sabha cannot have nominated members. So in the original constitution, both Lok Sabha and Rajya Sabha are having the nominated members, but presently who is having the nominated members? Only the Rajya Sabha. So anyways, this particular statement is wrong. Okay, so this is wrong. There was some small typo in this particular question. Okay, anyways, come to the second question. There is a constitutional provision for nominating 2 members belonging to the Anglo-Indian community to the Rajya Sabha. Is it true? So this was there for the Lok Sabha initially, but however it has been done away with right now. So what is the amendment by which it was done away with? 104th Constitutional Amendment Act, it was done away with. There is no constitutional bar for a nominated member to be appointed as a union minister. Is it true? Is there a constitutional restriction to appoint a nominated member as a minister? There is no such restriction. So therefore this particular statement is true. A nominated member can vote in the presidential election. Can a nominated member vote in the presidential election? No. Be it Lok Sabha or Rajya Sabha, that is not possible. So what is the answer in this case? It is only option C. Okay, come to the next question. Consider the following statements. The joint sitting of the 2 houses of the parliament in India can be sanctioned under Article 108 of the Constitution. Is that true? Can it be sanctioned under Article 108 of the Constitution? Now tell me, who is supposed to convene a joint sitting? Can anyone tell me who is supposed to convene a joint sitting? It is the president who can convene a joint sitting, and that is not a discretionary power of the president. It is based on what is called as the aid and advice of the Council of Ministers. Okay, whenever a joint sitting is convened, after it is brought into the joint sitting, who is supposed to preside over the joint sitting? The speaker. In the absence of the speaker, deputy speaker. In the absence of both speaker and the deputy speaker, it is a deputy chairman of Rajya Sabha, not the chairman of Rajya Sabha. Is this explicitly mentioned in the Constitution? Yes? How many of you think this is explicitly mentioned in the Constitution? How many of you think it is not mentioned in the Constitution? It is not explicitly mentioned in the Constitution. If you read Article 108 of the Constitution, Article 108 of the Constitution gives this power to the President. But however, Article 108 of the Constitution is only allowing the President to make an order in this regard. The President can make rules in this particular regard as to who can preside over the House. So accordingly, the President has made the rules, but it is not explicitly mentioned in the Constitution. Anyways, UPSC may not go in depth into all those things, but probably in case if they ask you, the benefit that you may get because sitting in the class, spending the time, these are all some of the benefits that you should get, okay, which the other students may not get, okay. So this is not specifically mentioned in the Constitution, but the President has made a rule. So it's the speaker. In the absence of the speaker, the deputy speaker. If in the absence of both, then it is the deputy chairman of the Rajya Sabha, okay. The first joint sitting of Lok Sabha and Rajya Sabha was held in the year 1961. Is it true? Yes, factually it is true. 1961 for the dowry prohibition bill. So it was for the first time that they met, and the second time that they met in the year 1977. 1977 in case of what is called as the Banking Service Repeal Bill, Banking Services Commission Repeal Bill, okay. So that was in the second time. And when was the third time? Third time it was in the year 2002 for the Prevention of Terrorism Bill, okay. So POTA bill, that is the third time that they met. So that is not very important, but just remember 3 times they have met till this point of time, first in 1961. So this is true, this is also true. The second sitting of the two houses of the Indian Parliament was held to pass the Banking Services Commission Repeal Bill. This was also true, 1977. So this is also true. So which of the statements given above are correct? It is 1, 2 and 3. The last time they have sat in 2002 for the repeal of what is called as the POTA bill, for the POTA bill, okay. So Prevention of Terrorism Act. Okay, so come to the next question. Which one of the following authorities recommend the principle governing the granting aids to the revenue of the granting aids of the granting aid of the revenues to the state out of the Consolidated Fund of India? We know under the Constitution that the center can give some granting aid to the states. So who will recommend the center to give some granting aid to the states? That's a question. It is the Finance Commission of India. Does anyone know under which article this happens? Under Article 280 is where the Finance Commission can give the recommendation, but which article in the Constitution allows a center to give this granting aid to the states? Does anyone know? See, they can, the Finance Commission makes a recommendation, that is all okay, but there is a specific article in the Constitution that allows the center to give the granting aid to the states. It is Article 275 of the Constitution. Anyways, I will discuss that when I take up the center-state relationship in a little detail. So the answer here is the Finance Commission, and while the Finance Commission gives a recommendation under Article 280, but which article allows a center to give the granting aid to the states is Article 275 of the Constitution. The speaker can ask a member of a house to stop speaking and let another member speak. This phenomena is what is the phenomena? yielding the floor. That means he is giving somebody else to talk. So it is a speaker's permission with whom anybody can talk in the house, not without the permission of the speaker. So therefore the speaker can allow somebody else to talk during the discussion. So that is basically what is called as yielding the floor. What is interpellations? In the parliamentary language, interpellation means questions, asking questions in the house, that is basically interpellations. What is crossing the floor? Crossing the floor means a member is defecting. A member is defecting from one party to another party, that is basically what is called as crossing the floor. And then what is decorum as per the parliamentary language? Maintaining the discipline in the house. So that is basically what is called as decorum. What happened? What is the answer? Okay, so the answer is yielding the floor in this case. Okay, so come to a very important area. Every year the question is coming from the money bill. Every year, every single year UPSC is asking. Okay, tell me where is this money bill or the subject matter of the money bill is defined in the constitution? Which article? 110 or 109? I am talking about the subject matter of the money bill, no confusion, article 110. But the procedure for a money bill is given under article 109. So do not get confused. So UPSC rarely asks articles, but last year I think they asked the article. So the subject matter of the money bill is article 110, procedure for a money bill is article 109. Okay, so when a money bill is presented to the president, I will discuss about the money bill. When a money bill is presented to the president, what are the options that the president can exercise? He can give the assent. Can he withhold the assent? Yes, he can withhold the assent, but he cannot send it for reconsideration. That is not possible because the matter is so urgent and so important, you cannot waste the time. Withholding the assent to the bill on certain conditions he can do that. Of course, it is not his discretionary power. Yes, under certain circumstances, certain situations he can do it, but not returning it for reconsideration. Okay, when a bill is considered to be a money bill, in fact, have it in your mind very clearly that all money bills are financial bills. Is it true to say all money bills are financial bills? Because in general, what is a financial bill? Any bill which deals with the financial matters of the government. It can be revenue, it can be expenditure, it can be any other financial matters. If a bill deals with financial matters, then that's a financial bill. And in fact, all money bills are financial bills. But can we say that all financial bills are money bills? That is not possible because there are different types of financial bills. You have a money bill, and then apart from that, the financial bills are classified into type 1 and type 2 financial bills. Usually they are classified depending upon the subject matter of that particular bill, what they deal with. So therefore, to say all financial bills are money bills is wrong, but all money bills are financial bills. Is that clear to all of you? First thing that you will have to keep in your mind. Okay, then what type of financial bills can be considered to be money bill? That's a question. So I said in general, if they deal with the finances, they are financial bills. But if they deal with specific type of finance matters or financial matters, then they are considered to be what is called as money bill, for which you should have an understanding of what is mentioned in article 110 of the constitution. So article 110 of the constitution categorically says it deals with certain subject matters. In fact, to be very specific, it deals with 6 subject matters. So if any financial bill which contains only these subject matters, only the subject matter is very important. Only the subject matters which is mentioned in article 110 of the constitution. Only the subject matters mentioned in article 110. It can be one matter, it can be two matter, or it can be all the matters. It does not matter, but it shall not contain any of the other matter apart from what is mentioned in article 110. So if any financial bill is containing only those subject matters which is mentioned in article 110, then they would be considered to be what? It would be certified as a money bill by the speaker. So therefore, tell me, at the time of introduction of a bill, is it a money bill? It is not a money bill. It is only a financial bill which is containing only those matters which is mentioned in article 110. Then subsequently, who will certify this particular bill as a money bill? Then the speaker will certify this particular bill as a money bill before it is sent to the Rajya Sabha. So once a speaker certifies this bill as a money bill before it is sent to the Rajya Sabha, then the Rajya Sabha will know what are their powers with regard to this particular bill, and what is the maximum power of the Rajya Sabha with regard to this particular bill. that they can delay the passage of the bill by 14 days. Can they reject a money bill, Rajya Sabha? Can they amend the money bill? Yes, they can amend a money bill. They can suggest some amendments and they can send it back, but they can do it within 14 days. But however, it is not binding upon what? It is not binding upon the Lok Sabha. And if they do not take any action for 14 days, then the bill is deemed to be passed. If they suggest amendments and send it back to the Lok Sabha may accept or may not accept. But all these things has to happen within 14 days. So therefore, their maximum power is that they can delay it by 14 days. Okay, again I am repeating it. Can all the money bills be considered to be financial bills? Can all the financial bill be considered to be money bills? No, because there are other types of financial bills which are basically financial bill type 1 and type 2. So therefore, any financial bill which contains only those subject matters mentioned in Article 110, then they can be certified as a money bill. So what is a financial bill type 1? It is also a financial bill. It is also dealing with finances, but this does not exclusively contain only those matters mentioned in Article 110. That means financial bill type 1 will partly have some items or at least one of the item which is mentioned in Article 110, but it does not exclusively contain only those matters. So that means a financial bill type 1 is a classic example of combination of a money bill and an ordinary bill. So it will have subject matter related to the finance bill and it will money bill. It will also have subject matter related to an ordinary bill. That is basically what is called as a financial bill type 1. So in case of a financial bill type 1, when the bill goes to the president, what are the options in the hands of the president? Can he give the assent? Can he withhold the assent? Can he send it for reconsideration? Yes. Remember, he can do everything similar to that of an ordinary bill because it is partly an ordinary bill. Now, what is a financial bill type 2? A financial bill type 2 is also related to matters of finances, but it does not contain any of the matter mentioned in Article 110. So not even a single subject matter which is there in Article 110 is there in this financial bill type 2. But it also has a financial implications to the government. That's a financial bill type 2. So in case of a financial bill type 2, what are the options in the hands of the president? He can do everything as that of an ordinary bill. He can give the assent, withhold the assent, send it for reconsideration. All these things can be done. Okay, now coming back to the first point. If any bill which has only those matters which is mentioned in Article 110, then such financial bill can be certified as a money bill. So whenever a bill is introduced in the parliament, and if this bill is having only those subject matters, what is the subject matter of the bill? Only those subject matter which is mentioned in Article 110 of the Constitution. In this particular case, as per the procedure, it is saying that this bill can be introduced where? Only in the Lok Sabha, and it can be introduced only with a prior recommendation of the president. That is why we are saying that the money bill can be introduced only in the Lok Sabha with a prior recommendation of the president. But initially itself it is not certified as a money bill, but it is containing only those subject matters for the money bill. So it can be introduced where? Only in the Lok Sabha with a prior recommendation of the president. And then it goes through all the steps passed by Lok Sabha, and what is the maximum power in the hands of Rajya Sabha? Delayed by 14 days. Then it goes to the president. The president can either give the assent or withhold the assent. Is it clear? Okay, now the procedure in the constitution is also saying that if any bill which is containing any of those matters which is mentioned in Article 110, and in addition to that it has certain other provisions also, that is basically a financial bill type 1. This can also be introduced only in the Lok Sabha and with a prior recommendation of the president. So this is the only similarity between a financial bill type 1 and the money bill. In all other cases, financial bill type 1 is similar to that of an ordinary bill. So therefore, once it is passed from the Lok Sabha to the Rajya Sabha, what are all the options in the hands of Rajya Sabha? The Rajya Sabha can accept the bill, so they can accept it, or they can reject it, or they can make amendments and send it back to the Lok Sabha, or they do not take any action for a period of 6 months. And we know that in certain cases there arise what is called as a deadlock. If they accept in the same version, then it will go to the president. In certain other cases there will be a deadlock. What are the conditions that there will be a deadlock? If they don't accept it, that is, if they make an amendment, if they reject it, there is a deadlock, or if they make an amendment and send it back to the Lok Sabha, which is not acceptable to the Lok Sabha, then also there is a deadlock, or if they do not take any action for a period of 6 months, then also there is a deadlock. In case of a deadlock, then what will happen? If the government is serious on this bill, in case of a deadlock, then the government can request the president to convene a joint sitting. and then we have already seen what will happen in the joint sitting. Now the third type of bill is what is called as a financial bill type 2. A financial bill type 2 is similar to that of an ordinary bill. It is entirely similar to that of an ordinary bill, which means it can be introduced where? It can be introduced in either houses of the parliament, and there is no need for prior recommendation. The only difference between a financial bill type 2 and that of an ordinary bill is that in case of a financial bill type 2, procedurally it is little different. How? It requires a recommendation of the president after the bill is introduced in the houses. It is not the prior recommendation, so don't confuse. That means in case of a financial bill type 2, the bill can be introduced in the parliament, but after the introduction stage, what is the next stage for any bill? It will be either referred to the DRSCs or it goes for the second reading in the house, whatever may be the next stage. After the introduction of the bill cannot go to the next stage unless and until the president recommends for it. And this recommendation of the president is required separately in both the houses. So once introduced in the Lok Sabha also, the president recommends, then it goes to the next stage. Then it goes to the Rajya Sabha. The Rajya Sabha also, after introduction, the president recommends, then the bill goes to the next stage. In all other respects, it is similar to that of an ordinary bill. That means what are the options in the hands of the president in case of an financial bill type 2? He can give the assent, withhold the assent, or send it for reconsideration. And because there is no time limit, they may exercise the packet veto also. Okay, so these are all the things that you should understand. So with that, please come to this particular question. So we almost discussed most of the things. If there is any specific thing input I have to give, I will give it when I discuss the question. Now please come to the question. A money bill can be tabled in either houses of the parliament. Is it possible? No, because this is a financial bill which contains only those matters which is mentioned in article 110. So therefore, where it can be tabled? Only in the Lok Sabha. So this is wrong. The Speaker of Lok Sabha is the final authority to decide whether a bill is a money bill or not. Is it true? Yes, within the house he is the final authority. Now don't confuse whether it can be subject to judicial review or not. That's not the question. Who is the final authority within the house to decide whether it is a money bill or not? It is the Speaker. The Speaker is the final authority to decide whether it is a money bill or not. So this is true. They are asking which is not correct. Okay, anyways, we will see the other options. The Rajya Sabha must return the money bill passed by the Lok Sabha and send it for the consideration within 14 days. Is it true? Yes, the maximum time that they have got is 14 days. The president cannot return a money bill to the Lok Sabha for reconsideration. In fact, not only to the Lok Sabha, in general. Okay, he cannot send it because why they are using Lok Sabha is, in fact, in case of a money bill, who is the final authority? It is the Lok Sabha. Okay, so therefore, this is also true. So therefore, what is the right answer in this case? It is A, because it is asking for which of the following is not correct. Who among the following have the right to vote in the elections of both Lok Sabha and Rajya Sabha? So who among the following, or who is the electoral college both in case of Lok Sabha and Rajya Sabha? That's the question. So elected members of lower house of the parliament, can they vote in the Rajya Sabha elections? That's a question. Can they vote in the Rajya Sabha elections? So who among the given can vote in both elections to the Lok Sabha and Rajya Sabha? That's a question. Can we vote to the Lok Sabha elections? Can we vote to the Rajya Sabha elections? So therefore, you'll have to understand who is eligible to vote in the Rajya Sabha elections. Who is eligible to vote in the Rajya Sabha elections? MLAs in case of the state, the elected members of the legislative assemblies. So they are eligible. So therefore, try to give an answer. So the elected members of lower house of the parliament is not the answer. The elected members of upper house of the parliament is also not the answer. So then who else is the answer? The elected members of upper house of the state legislature? No. The elected members of the lower house of the state legislature. That means the MLAs will have the right to vote in the Lok Sabha elections, and they also have the right to vote in the Rajya Sabha elections. Is that clear? So as a citizen of India, they have the right to vote in the Lok Sabha elections. As an elected member of the legislative assembly, they are part of the electoral college when it comes to the Rajya Sabha elections. Is that clear to all of you? Any doubt here? Lok Sabha? General elections. Yes. As a common citizen, he will have a right to vote. So there is no problem with regard to that. Okay. So the elected members of lower house of the state legislature. That means an MLA will have the right to vote in the Lok Sabha elections. The MLA will, of course, he will have the right to vote in the Lok Sabha elections. That is the answer. What is the answer here? It is option B. Is that clear to all of you? Don't hesitate to ask question. If you have questions, please ask it at least after the class is over. Okay. Otherwise, your doubt will always remain a doubt. Okay. And exactly that will appear in the examination. So you might think that I should have asked this particular question. Okay. If an election to a state legislative assembly, if in an election to the state legislative assembly, if in an election to the state legislative assembly, the candidate who is declared elected loses his deposit. See, as per the Representation of People Act and the rules of the elections, if any candidate has not got 1/6 of the total valid votes, then you lose their deposit. So every person who is contesting election to either Lok Sabha or to the legislative assembly, they have to pay a deposit amount, 10,000, 15,000, some amount is there. So that deposit amount will be given back by the Election Commission of India if they minimum secure how much votes? 1/6 of the votes that has been polled. If they fail to secure this 1/6 of the vote that has been polled, then they lose their deposit. But still the candidate can be a winner of the election. That is not possible. That is possible. Why it is possible? Because the election is based on what? The election is based on the first past the post system. All that he has to make sure is that he should get more number of votes than the other candidates. Not necessarily 1/6 of the votes, even less than that can make him a winner. But in that case, what is the possibility? That is this particular question. If in an election to the state legislative assembly, the candidate who is declared elected loses his deposit, it means what? Can he still be a winner? Is it possible that he has lost deposit but still a winner? Okay, that is possible. Then which of the following can be the situation? The polling was poor. Not necessarily, we do not know. The polling can be 100% polling also. 100% of the people have voted, but none of them got 1/6 of the vote because there was a very tough competition. But ultimately, one got more number of votes than all other candidates. So therefore, it is not necessarily. The election was for a multi-member constituency. Multi-member constituency is wrong. Multi-member constituency means from a constituency, multiple winners can be there. But our election is based on single-member constituency. So therefore, that is not definitely right. This is not necessarily the case. The elected candidate's victory over his nearest rival was very marginal. That also we are not sure. Now let us assume that a particular candidate has not got 1/6 of the vote, but he has got more number of votes than all other candidates, where the margin between the winner and the other candidates are very big. That is also possible. But the only possibility definitely we can say that is possible in this case is that a very large number of candidates have contested in the election. Suppose let us assume 1000 voters, but 100 people have contested in the election. So therefore, the vote share has been divided by number of candidates. So therefore, nobody has got the deposit, but still there is a winner because of the first past the post system. So what would be the most appropriate answer here? A very large number of candidates have contested in the election. Is that clear to all of you? One-sixth of the vote polled, I think, not the total number of votes, because you never know how many people will participate. So as far as my knowledge is concerned, it is the total number of votes polled. Okay. Okay, so come to the next question. Which one of the following statement is correct? Statement A: all the members of Rajya Sabha are elected by the state legislative assemblies. Is it true? All the members of Rajya Sabha, whoever is elected, they get elected, but they are also nominated members. So therefore, to say all the members of Rajya Sabha are elected from the state legislative assembly is wrong. As the vice president is ex officio chairman of the Rajya Sabha, only a member of Rajya Sabha can contest for the office of the vice president. There is no relation between these two things. There is a separate qualification that is given to who can contest the office of the vice president. Anyone who is a citizen and who has completed 35 years of age. Okay, so therefore here not necessarily only a person who is part of the Rajya Sabha. The Constitution of India explicitly prohibits the appointment of a nominated member of Rajya Sabha to the post of a minister. Is that true? Even someone who is not a member can also become the minister. So therefore, that does not explicitly prohibit. So what is the answer here? None of the above is the answer. Come to the next question. Which one of the following statements regarding the office of the speaker is correct? Very, very important. Two areas I will say every year question is coming. One is from the post of the presiding officers, most likely from the speaker, and the second thing is definitely from the bills. These are all areas definitely they will ask questions. Which one of the following statements regarding the office of the speaker is correct? Statement 1. He holds office during the pleasure of the president. The president has nothing to do with the speaker because the speaker is elected from among the members of the house. The only way that he can be removed is by a motion that is passed in the which house? Lok Sabha or both Lok Sabha and Rajya Sabha? Only in the Lok Sabha. With regard to all the presiding officer, it is only with regard to the respective house. And what is the majority with which it has to be passed? To remove the speaker. Now please understand, for his election it is simple majority, for the removal for all the speakers it is effective majority. Okay. So it is for all the presiding officers, sorry, it is effective majority. So he holds office during the pleasure of the president is wrong. He need not be a member of the house at the time of his election, but has to become a member of the house within 6 months from the date of his election. Is it true? In fact, the only condition that is given is he should be a member of that particular house at the time of election. So this is also wrong. He loses his office if the house is dissolved before the end of the normal tenure. Is it true? The speaker's term is not coterminous with the term of the house. They are not one and the same. Okay, so that is should be very, very clear in your mind. If he intends to resign, the letter of his resignation to be submitted to the deputy speaker. Is it true? Yes. But what if there is no deputy speaker? One of the student was asking, in the last two Lok Sabha there was no deputy speaker. So what if the deputy speaker is not there and if the speaker has to submit the resignation? Then nothing is given in the constitution, but as per the rules of the Lok Sabha, then the resignation is submitted to the Secretary General of Lok Sabha. Is that clear? So to whom it will be submitted? It is submitted to the Secretary General of Lok Sabha, but as per the rules of the house. So this is true. The answer is option D. Which one of the following are the financial committees of the Parliament in India? Which of the following are the financial committees? Public Accounts Committee, Estimates Committee, and the Committee on Public Sector Undertaking. Among all the three committees, which is the largest financial committee? It is the Estimates Committee. And in the Estimates Committee, the members are elected or nominated? All the members are elected based on the principle of proportional representation, and all the members are only from the Lok Sabha. Who appoints a chairperson of the Estimates Committee? The Speaker of Lok Sabha, and the person is usually from the ruling party. And among all the committees, which committee will have the chairman from the opposition party? Public Accounts Committee, and that is by a parliamentary conventional practice. Is that clear? Very, very important. So every year they do ask a question from this particular area also. So come to the next question. Which one of the following correctly reflects the position of the upper house of the upper house of the state legislature as compared to the position of upper house of the parliament? So they are making a comparison between the legislative council and the Rajya Sabha in this particular question. So look into the question. Statement A: while 1/3 of the members of the Rajya Sabha retire every second year, 1/4 of the members of the legislative council retire every 18 months. Is that clear? In both the cases, 1/3 of the members retire every second year. So this is wrong. So who is authority to create or to abolish a legislative council? Who is authority? Parliament or the concerned state legislative assembly? It is a parliament which is authority. You should not have any doubt, but the parliament cannot do it suo motu on its own. Only on the basis of resolution passed by the concerned state legislative assembly, then they can either create or they can abolish. And I said that the legislative assembly has to pass a resolution, and what is the majority with which they have to pass this resolution? by special majority they have to pass it, not less than 2/3 of the members present and voting plus absolute majority. So, if they pass it, and is the resolution passed by the state legislative assembly, is it binding upon the parliament? Is it necessary for the parliament to immediately enact a law? It is not binding upon the parliament. Okay. There is no provision for a joint sitting of the legislative assembly and the legislative council in the states for resolving the deadlocks. Well, there is such a provision in case of the houses of the parliament. Is it true? Yes, there is no provision for deadlock in case of the state legislature. Now, why? Because the legislative council do not have equal powers as that of the assembly when it comes to the ordinary bills. Leave about the money bills, but in case of even the ordinary bills, they do not have equal powers. I will discuss that in detail. There are few questions that is coming, but just try to answer this question. What is the maximum power in the hands of the legislative council to delay a bill, or how long they can delay a bill? What is the maximum time? 4 months is the maximum time. 3 months in the first instance and 1 month in the second instance. So, their maximum power is only to delay by 4 months. And what all the power they can exercise, I will discuss. I think subsequently the questions are there, I will discuss. Well, no bill other than the money bill can originate in the state legislative council. No bill can originate in the Rajya Sabha. Is it true? This is definitely wrong. Okay, so this is a complete wrong statement. Well, Rajya Sabha has 12 nominated members. The state legislative council has none. While the Rajya Sabha has 12 nominated members, the legislative council has 1/6 of the members to be nominated by the governor. So, therefore, this is also wrong. Okay, whenever a legislative council is created or abolished, is there a need to make change in the constitution? Will there be changes in the constitution when a legislative council is abolished or created? Yes or no? Yes, no, no. There is a need to make change in article 168 of the constitution. So, article 168 of the constitution will mention the names of the state which has got the legislative councils. So, therefore, yes, there will be definitely change in the constitution, but the question is, to make this change, is it necessary to make a constitutional amendment under article 368, or can it be done by a simple act of parliament? It can be done by a simple act of parliament. Such an exception is given in the constitution. Okay. So, you do not have to make a constitutional amendment under article 368. By a simple act of parliament, you can amend article 168 of the constitution. Okay. Come to question number 195. Which of the following are the circumstances under which an elected member of parliament may be disqualified on the grounds of defection? Now, where is the ground for defection mentioned in the constitution? What is the ground on which they can be disqualified? It is mentioned in the 10th schedule of the constitution. Just knowing the schedule itself is very important. Many times questions have come from this particular area. Anyways, I will discuss about the schedules in the later classes. So, it is mentioned in the schedule 10 of the constitution. 4 grounds are given in schedule 10. So, what are the 4 grounds? If somebody gives up the party membership voluntarily, somebody abstains or act contrary to the party direction, these are all for people who are belonging to a party. And then one is for a nominated member. If any nominated member joins any party after 6 months, within 6 months is okay, but after 6 months he is liable to be disqualified. Any independent candidate joins any party at any time during the term of the house. If he joins, then also he is liable to be disqualified. These are all the only 4 things that is given in in the schedule 10 of the constitution. So, now please come here. If he voluntarily gives up the membership of political party, is it true? Yes. So, this is definitely true, but the Supreme Court of India has said voluntarily giving up the party membership not necessarily only mean that he has joined another party. He can be in the same party and he can do something against a party. That also from his conduct, the presiding officer can come to a conclusion that he has voluntarily given up the party membership. So, anyways, this is definitely true. If he votes or abstains from voting contrary to any direction that is issued by his political party without prior permission of the political party, is it true? That means, can someone take a prior permission from the party? Yes, they can take prior permission from the party. If the party accepts, then it is okay, but even without prior permission they can do it, but then they have to ask the party to condone them within 15 days. So, these are all some exceptions given in the constitution, but anyways, in general this particular statement is true. If he speaks against a political party, what about this? Where he is speaking, what he is speaking, these things are not very clear here. So just because speaking against a party doesn't mean at some point of the other someone will speak against the leadership. So therefore not everybody is liable to be disqualified. So this is not a ground that is mentioned in the constitution. So we'll have to understand what he is speaking, what if the leader itself is wrong. It is not necessarily always the party is right, the individual can be right. In which forum he is doing it, what is the damage to the party? So nothing of that sort is very clear. So statement is very vague, and it is also not directly given in the constitution. So therefore we cannot assume that it may fall under all those things. See whether it is there in the constitution or not. So therefore this particular statement is wrong. If he joins a political party other than the party on whose ticket he has contested the election, so this is he is voluntarily giving up the party membership. Okay, so this is true. So which of the above is are correct? What is the answer here? 1, 2 and 4 only. So come to the next question. Who is authorized to decide over a dispute regarding disqualification of a member of a parliament? Who is authority? Who is authority? Is it the Election Commission of India, the Chief Election Commissioner, the President, the Speaker? Who is authority? Now please try to understand that in case of all the disqualification except the anti-defection law, who is authority to disqualify the members of the parliament? It is the President of India. The Election Commission of India has no authority to disqualify. The Election Commission of India will only make the recommendation after making an inquiry. Who is authority to disqualify the members of the parliament? It is the President. And who is authority to disqualify the members of the state legislature? It is the governor of that particular state. Except in case of anti-defection law. Only in case of anti-defection law, the speaker or the presiding officer will have the power to disqualify. In all other cases, it is the president and the governors. After the Supreme Court ruling, in certain cases they have said there is an automatic disqualification when there is a conviction in a court of law, but otherwise this is the thing that you have to understand. So what is the answer here? It is the President of India. Okay, now the students ask me that with regard to the disqualification of the members of the parliament also, do the President act on the aid and advice of the Council of Ministers? No, in this case definitely not. Then the government Council of Ministers can advise to disqualify all the members of the opposition party. So here it does not happen that way, but on the recommendation of what? The Election Commission of India, and the recommendation of the Election Commission of India is binding upon the President. Okay, once the President disqualifies a member of parliament, is it subject to further appeal anywhere? Can that decision of the President be appealed? Yes, that is not a final decision. It can be challenged in the High Court concerned. From wherever a member has contested the election from that particular state, they can go to the High Court and challenge this order. And a further appeal can also be made to the Supreme Court of India. Okay. That is what I have said just now. Okay, so it is based on the recommendation that is given by the Election Commission of India, not on the aid and advice of the Council of Ministers. Okay, so please come to question number 197. In the estimation of expenditure charged upon the Consolidated Fund of India, okay, when the budget is presented, that is annual financial statement is presented, the budget has to be presented in the form of estimated revenue and estimated expenditure, and the estimated expenditure has to be further separated into two columns. One is the made expenditure, another is the charge expenditure. So can anyone tell me what is the difference between the made expenditure and the charge expenditure? This is how the budget has to be presented. What is the difference between these two things? Which expenditure is discussed and also put to vote? At which stage it is discussed and put to vote? Which stage of the budgetary process? The second reading stage? Not in the second reading stage. Which stage it is discussed and put to vote? I mean the expenditure is put to vote, discussed and put to vote. It is on the vote on demand for grant stage. So when you go to the vote on demand for grant stage, if you look into the expenditure, those expenditures which are made expenditures, it is discussed as well as put to vote. But whereas the charge expenditures can be discussed, but it is not put to vote. Without voting, it has to be passed. That is why these expenditures are considered to be very important expenditures. So therefore, the person who is preparing the budget, that is the Department of Economic Affairs, whoever is concerned with consolidating the entire budget, before giving it to the finance minister, they should be aware of what should be part of charge expenditure and what should be part of the made expenditure. So from where do we get this information as to what is when it comes to the union budget, and where do we know as to what are the charge expenditure? Article 112 of the Constitution. Is Article 112 of the Constitution is only source for charge expenditure? Is it the only area where the charge expenditure is mentioned? So what are the source of charge expenditure? Because the person, as long as he knows what is charge expenditure, he cannot fill this particular column, and these two things are mutually exclusive. Whatever is not a charge expenditure, that's a made expenditure. But so at least you should know what is a charge expenditure, so that the other expenditures can be put in the made column. So how do we know what is a charge expenditure? It is mentioned in Article 112 of the Constitution. It is mentioned in certain other provisions of the Constitution. Say for example, Article 146 is there. What is Article 146 related to? Does anyone know? Salary allowances of whom? Judges. The judges of the Supreme Court are all mentioned in Article 112 itself. What is Article 146? Where it is mentioning the staffs and the other clerks, the officers and the other servants of the Supreme Court, their salaries and allowances shall be charged upon the consolidated fund of India. So therefore, whatever is there in Article 112, and apart from Article 112, any of the other provisions of the Constitution where they declare an expenditure to be a charge expenditure, and apart from that, the law made by the Parliament. The Parliament can make a law, and by that law, if it declares an expenditure to be a charge expenditure, that shall also be a charge expenditure. So all these things will be part of what is called as a charge expenditure. So remaining expenditures will be what? Made expenditure. So once you know this, when it is a charge expenditure, when the budgetary process, when it comes to the vote on demand for grant stage, while the made expenditure is discussed and then put to vote, whereas the charge expenditure can be only discussed, but it is not put to vote. That means practically you cannot make any changes to what is called as a charge expenditure. Even to the made expenditure, there may not be any change per se, because in the made expenditure also they are discussed and put to vote, and while putting it to vote, there can be some cut motions that can be introduced if at all they are intending to make some changes. And what are the cut motions that can be introduced? It can be a policy cut motion, it can be a token cut motion, it can be an economy cut motion. When I say policy cut motion, let the demand be reduced to rupee 1. When I say it is a economy cut motion, let the demand be reduced by a specified amount. And when I say it is a token cut motion, when the demand be reduced by rupees 100, it does not make any change. But although those motions can be introduced, none of these motions will be passed. If any of these motions are passed, then what can be assumed? That means it is a no confidence motion against the government. So therefore, in this case also changes are unlikely. But however, the cut motions can be introduced. But whereas in case of charge expenditure, because it is not put to vote, the cut motions cannot be introduced there. These are all considered to be very important expenditures. Alright. So this is something basically you have to understand. But what are all charge expenditure? There is a separate question that I will further discuss. But it is very, very important for you to know the difference between the made expenditure and the charge expenditure. Is that clear to all of you? Yes. Please come to the question. In the estimation of expenditure, if the estimation of expenditure is charged on the consolidated fund of India, the Parliament has no power to discuss. They have the power to discuss. Yes. So this is wrong. Full power to discuss. Yes, they have full power to discuss. Full power to discuss during financial emergency. Not necessarily in financial emergency. Every regular budget they can discuss. This is all to distract and confuse you. Don't get confused. None of the above. So what is the answer? It is option B. Okay. What is the maximum gap between two sessions of the Parliament? Who is supposed to summon the session and prorogue the session? Is it to be done on the aid and advice of the Council of Ministers? And which article in the constitution talks about this? Article 85. Okay, if you are not remembering, it's okay, but it is Article 85. So what can be the maximum recess in the parliament? 6 months. So if it say, so recess is the word that technically that is used. Okay, don't get confused if they put the word recess. So maximum it shall be 6 months. Is there any minimum requirement as to how many days the parliament has to be in session? Is there any minimum number of requirement in the constitution as to how many sessions has to be in a given year? Is there any minimum requirement? No, nothing is given. Only one information is given, is that the gap between two sessions should not be more than 6 months. Is that clear to all of you? Can the parliament session be convened in a different place apart from the parliament? Is that possible? Yes, because the constitution does not say it has to be convened only in the parliament. It can be convened in other places also. So today we have 3 sessions in the parliament, and the 3 sessions in the parliament is based on what is called as a conventional practice, and nothing is there in the constitution. So what is the answer for this particular question? The maximum gap between 2 sessions of the parliament is 6 months. So what is the answer? Option A. The deputy chairman of Rajya Sabha, question number 199. The deputy chairman of Rajya Sabha can be removed by a resolution passed by, what is the majority with which he can be removed? By effective majority. In all the cases when it comes to removal, it is effective majority. The only exception is the President of India. Anyways, he is not a presiding officer. But the one thing that you have to remember is, when it is the chairman Rajya Sabha, it has to happen in both the houses, because he is not removed as a chairman Rajya Sabha, he is removed as a vice president of India. Okay. So what is the answer here? It has to be passed by, here it is 2/3 majority no, simple majority no, moved in Rajya Sabha but passed by Lok Sabha no, none of the above, because nothing is given, so it is none of the above is the answer. Okay, but there are certain important things that you have to remember. If a resolution is, if a notice is introduced with regard to removal of the deputy speaker in case of the Rajya Sabha, can the deputy speaker preside over the house? If the speaker is, if the deputy chairman, if a notice is introduced to remove the deputy chairman of Rajya Sabha, and let us assume the chairman is absent on a given day, can the deputy chairman still preside over the house? No, the deputy chairman cannot preside over the house once the notice is admitted. So who shall preside over the house? Panel of chairpersons. So vice chairpersons, I think. So they, anyone among them will preside over the house. Can the deputy chairman be present in the house and take part in the proceedings? Yes, he can do that. Can he vote in the first instance? Can he vote in the first instance? Then he becomes a normal member of the parliament in that house. So therefore, he can vote in the first instance. So remember that the casting vote is exercised by the presiding officer only when they are acting as a presiding, or when they are presiding over the house. Otherwise, they will vote in the first instance. Is that clear? So when a notice is there, he will have the right to present, he will have the right to participate in the proceedings, and he will also have the right to vote in the first instance, but not in case of casting of vote. That will be done only by someone who is presiding over the house. This is also true for both the speaker as well as the deputy speaker. But when the notice is introduced with regard to removal of the chairman of Rajya Sabha, who is also the vice president of India, so in that particular case, can he preside over the house? He cannot preside over the house. Can he present in the house? Can he participate in the proceedings in the house? He can participate in the proceedings. He can participate in the proceedings. Will he have the right to vote in the first instance? He will not have the right to vote in the first instance, because the difference between the chairman Rajya Sabha and all the other presiding officer, the chairman Rajya Sabha is not a member of parliament, but whereas all the 3 members are members of parliament, so therefore they will have the right to vote in the first instance. Is that clear to all of you? Very, very important area, don't get confused. Okay, is that clear? Does anyone want me to repeat this? Clear? Okay. So please come to the next question. What is the minimum percentage of strength of opposition is required to the state legislature for the appointment of opposition leader in case of states? What is the minimum requirement? Not less than 1/10 of the membership of that particular house. But is it mentioned in the constitution? it is only a conventional practice that we follow. Okay, it is not mentioned in the constitution. So the answer here is none of the above. Okay. Hmm. No, the ruling party will not recognize them as the, there is no need for them to recognize. Anyways, there is no legal position in this regard, except in the parliament there is a legal position, but in case of the state legislature there is no such legal position. So the opposition will not recognize. Why would the government recognize that? Because opposition leader means they have to give them a status. So normally they will not allow that to happen. Hmm. Hmm. Majority means not the 1/10 minimum strength, huh? So they can talk and they can consider, but will it happen or not, that is for the government, but the government will not accept it, because that is a way that they can corner the opposition. Okay, that is how they can take a political advantage of that. Okay, so now we are done with 200 questions. We'll try to see how many more questions we can do in the parliament. Any questions? I'll just take a moment to see the online students question. Okay, so there's a question from one of the online student. The question is, sir, if the Lok Sabha speaker decides it is a money bill or a finance bill, if he says that the bill as a, so the question I think is, if it is not a money bill but he says it to be a money bill, he certifies it to be a money bill, is his decision final? Nothing can be done in the parliament. That is final and binding, and then the Rajya Sabha will have a power only to delay it by 14 days. But if if it is done arbitrarily, then subsequently it is subject to a judicial review in a court of law. That is a different thing, but within the parliament nothing can be done, because that authority is only to the speaker. Which is the important committee? Is it the public accounts committee or the estimates committee? So that is not the way to ask the question. UPSC will not ask, because every committee has their responsibility to do. So maybe they can ask based on the membership. So who are we to assess which is the most important committee? That is a very subjective nature. So such type of questions UPSC may not ask. Don't worry about that. But yes, they can ask you from the composition, from the election and all those things. And both have a very important role to play. The estimates committee play a very important role in terms of presenting the estimates in the first place, whereas a public accounts committee has a very important role in scrutinizing the report that is submitted by the CAG. So therefore both have an important role. Okay. Please come to the next question. When a money bill is passed by the parliament, the president has the power to what? Okay, just let me know what is your answer and the reason for that. So please try to give your reason and also the answer for this question. Okay, when a money bill is passed by the parliament, the president has a power to amend it. The president has no power to amend it. How the president can amend it? The president has no power to amend it. In fact, the president has no power to even send it for reconsideration. In the reconsideration also, he can suggest certain changes. He doesn't have the power to amend it. Okay, so anyways, this is definitely wrong. Okay, he can return it for reconsideration. He can also not do it. Maybe the confusion is between reject it or keep it with him. So you tell me what is the answer. Keep it with him. How many of you think keep it with him? How many of you think reject it? Okay, now see, you'll have to see what is there in the constitution. So whenever a money bill is presented to the president, what the president can do? He can give his assent, he can withhold his assent. These are the only two things that is given. So therefore, he cannot amend it, he cannot return it for reconsideration. He can withhold it, subject to certain conditions. The understanding is in certain conditions he can withhold it. Withholding means he is rejecting the bill. But there is no explicit mention of keeping it with him. That is because there is no time limit that is given in the constitution. He is exercising that pocket veto, but that should not be understood as a power that is given to the president under the constitution. So therefore, what is the right answer in this case? He can reject it. Is it clear? So the right answer is he can reject it, but he cannot keep it with him. So therefore, this is the right answer. The answer is what? It is option B. He is sitting on the bill because there is no time limit, but the constitution does not say the president to do that. So what is the power that is given to the president under the constitution? He can withhold it. So therefore, he can reject it, but not withhold it. Yes. But then the bill will not become an act. If he rejects it, then the bill does not become an act. No, you can ask me under what situation he can do it. So normally when the president is likely to do that, when a money bill is sent to him, just a moment, when a money bill is sent to him, and when he has received this particular money bill, and then let us assume that the government is the legislative, the Lok Sabha is dissolved. So therefore, he will withhold the assent to the bill, and if he withhold the assent to the bill does not become an act. It is as simple as that. So therefore, when the government is a legitimate government, the president cannot exercise his power. When the government is having a full majority in the Lok Sabha, then the president should not do that. And if the president is doing that, then what is the remedy? Then the president can be impeached, which is also not possible. So that is why the government is very careful in choosing the president, which we do not have a president for this. No president have done like that, because money bill has a very important implications for the government and of course to the people also. So therefore, the president will not do this. But if in case the money bill is sent to the president, but then the Lok Sabha is dissolved, so therefore he can reject it. That is very much possible. He can withhold the assent to the bill. Yes, what is your doubt? Okay. No, that can go for a change. The way that the bill has been introduced, not necessarily it is the same way it will be sent to the president. When it is made a prior recommendation, it can go in the parliament, the Lok Sabha can make changes, the Rajya Sabha can suggest some amendments which may be acceptable to the Lok Sabha. So therefore, when it comes to the president, is not in the same case. So that is the reason he can still use it. Okay. All right. So please, is it clear to all of you? Okay. Come to the next question. In which case a joint session of the Lok Sabha and the Rajya Sabha is convened by the president. So in which case a joint session can be convened? Statement A, when the finance bill is to be passed by the Lok Sabha and the Rajya Sabha with 2/3 majority. There is nothing in the constitution like this, some random thing to confuse the students, it has been given. Okay, so this is all distractors. To impeach a president, no, it has to be separately passed. So there is no joint sitting. If after a bill has been passed by one house and transmitted to the other house and the bill is rejected by the other house, is it true? Yes. So here the implied understanding is mostly it is an ordinary bill or any of the bill where there is a possibility of having a joint sitting. So this is definitely true. So definitely not all of the above. Okay. So the answer is option C. Come to the next question. Consider the following statements. Conviction on defamation is a ground for disqualification of a member of parliament. Is it true? Conviction on defamation, is it a ground for disqualification of a member of parliament? What are the grounds for disqualification of a member of parliament? What is there in the constitution? If he gives up the citizenship, if he becomes an undischarged insolvent, if he is of unsound mind declared by a competent court, if he holds any office of profit, and apart from that any of the grounds as per the law made by the parliament. And accordingly the Representation of People Act was enacted, and the Representation of People Act says that if somebody is convicted of any offence for 2 or more years, then they are liable to be disqualified, and they are liable to be disqualified, and there is a ban for another 6 years after they complete their conviction term. So with that knowledge, come here. Conviction on defamation is a ground for disqualification of a member of parliament. Mere conviction on the grounds of disqualification, is it a ground for disqualification? Yes or no? How many of you think no? How many of you think yes? Conviction on disqualification. Okay, conviction on conviction on defamation. But conviction on defamation, let us assume the punishment is only 6 months. Here the quantum of punishment is not given. So it is only saying conviction on defamation. In fact, the defamation, the maximum punishment for criminal defamation in our country is 2 years. So not necessarily in every case the judiciary will give 2 years of punishment. But what if the punishment is less than 2 years? So therefore my question is a mere conviction on the grounds of defamation, is it itself a ground for disqualification? No, unless and until the minimum punishment is how much? 2 years. Mr. Rahul Gandhi was unfortunate, he was given 2 years of punishment for criminal defamation. That's a maximum punishment under the law. So therefore, if that punishment was likely to continue, he has to be disqualified as a member of parliament, and another 6 years he would not be able to contest the election. But fortunately for him, the Supreme Court came for his rescue. They suspended the punishment itself till the time the matter will be finally decided by the Supreme Court. So therefore, the statement you'll have to see, the conviction on defamation is a ground for disqualification is not true. But if the minimum punishment is 2 years, then it is true. So therefore, this statement cannot be completely seen as a right thing, because we are not sure as to what is the quantum of punishment in this particular case. Is that clear to all of you? But there are certain offences where a mere conviction is itself enough to disqualify them. But defamation is not one such crime. But there are certain other offences where mere conviction itself is sufficient to disqualify them for another 6 years. Whatever may be the quantum of punishment, even if they are convicted with fine, still they can be disqualified immediately. But defamation is not one such offence. Can you just recall some of the offences? If they are convicted under hate speech, if they are convicted under the Prevention of Corruption Act, if they are convicted under the Civil Rights Act, if they are convicted under any of the terrorism related acts in our country, under those cases mere conviction itself is sufficient. But defamation is not a grave offence. So therefore mere conviction is not sufficient, but minimum punishment has to be how much? Minimum 2 years. Okay, so come to the next question. Defamation is a criminal offence under the Constitution. In fact, the Constitution does not deal with any of the criminal offences. So not only defamation, there are separate laws in our country which deals with the criminal laws. Okay, so therefore that is definitely not right. Any member of parliament convicted on the grounds of defection. So the question, this ground of defection will not be able to contest election for another 6 years after the completion of his term. This is not true. There is no restriction. Okay, so let us assume that a person who is convicted on the grounds of defection is not convicted, disqualified on the grounds of defection. Will they able to contest in the next election? Will they be able to contest in the by-election? Is it possible? Because once a member is disqualified on the grounds of defection, there is a vacancy in some constituency, and then the by-election is likely to come. Will they be able to contest in the by-election? Of course, they will be able to contest in the by-election. There is no such restriction. But one of the students was asking, will they be able to contest from the same party? That is for the party to decide. Will they be able to contest from the same party? That is for him and for the party to decide. I cannot say that, but it is very unlikely to happen. Just now he has defected that particular party. So therefore, that I cannot answer, but by common logic it is unlikely to happen. Okay, so what is the answer here? Any member of parliament convicted on the grounds of defection will not be able to contest election for another 6 years is wrong. Okay, so what is the answer here? Which of the above are incorrect? So all of the above. Consider the following statements with regard to the anti-defection law in India. So where is this anti-defection law mentioned? Okay, so 10th schedule. So when was this anti-defection law brought in? 52nd Constitutional Amendment Act 1985. Is there any other amendment related to the anti-defection law? Which amendment? 91st, very good. 91st Constitutional Amendment Act. So what change was brought in by the 91st Constitutional Amendment Act? They have brought in an exception with regard to the anti-defection law. So which was initially 1/3 split, and that 1/3 split was replaced by what is called as 2/3 merger. So these are all the factual things that you have to remember. And we already seen with regard to, when it comes to the defection, the grounds for defection, which is mentioned in the 10th schedule. And who is authority to disqualify? The members of the parliament, not the speaker, the presiding officers. Not necessarily the speaker, the presiding officer is the authority. the Lok Sabha Speaker as well as the Rajya Sabha Chairman. Is there any time limit for the Speaker to decide the disqualification petitions? There is no time limit that is mentioned in the constitution, but some of the Supreme Court has mentioned reasonable time frame, where they also said it to be 3 months, but that is not a binding aspect of the judgment, so therefore there is no time limit as of now. Can the presiding officer take an anti-defection petition suo moto? Can they raise it on their own? That is not at all possible. It is only based on a petition that is brought in front of the presiding officer. Okay. So these are all some information, probably you can keep it in your mind from the prelims point of view. Okay, come to the first statement. The President of India and the governors of the state are the disqualifying authority in case of defection under the constitution. So who is the disqualifying authority? It is a presiding officer, not the president. In all other cases, it is a president and the governors. In this case, it is a presiding officer. Once disqualified under the law, the legislature cannot contest election from the constituency where he or she got elected. There is no such restriction. They can contest the election. But there is one restriction for a person who is disqualified on the grounds of defection. Now we know, let us assume, we have already seen that a person who is not even a member of parliament, he or she can be appointed as a minister. How long he or she can be appointed as a minister? Within a period of 6 months. But that is not applicable for a person who is disqualified under defection. Suppose if somebody is disqualified under defection, then he is not a member of parliament or a member of state legislature. Can he or she be appointed as a minister for 6 months? Not possible. They will not be eligible to be appointed as a minister unless and until they get elected back to the house. So they can contest in the by-election, they can get elected, that's a different thing, but they cannot be appointed as a minister. But once they get elected, can they be appointed as a minister? Of course, yes, that they can be appointed. So once disqualified, they cannot contest election from the constituency. This is wrong, they can contest. The 10th schedule of the constitution deals with the anti-defection law. Is it true? Yes, the 10th schedule of the constitution deals with that. Is it 9? Okay, so therefore it is wrong. So it is the 10th schedule. So what is the answer here? Huh? Okay, we'll make a small change. Instead of either we'll do that or we'll have to make none of the above. So we'll do this. Okay, we'll make it 10th schedule. The 10th schedule of the constitution deals with anti-defection law. Choose the correct answer. What is the answer? 3 only. Okay, so this is a typo. I think instead of my intention was to put 10th schedule, but somehow it came as 9th schedule. So what is the answer here? It is option B. Consider the following statements with regard to motion of thanks. So yesterday itself I have discussed about the motion of thanks. What are the 2 occasions where this motion of thanks happens? Every year during the first session and also first session after the general election. Now in both the cases, the government will prepare a speech for the president to deliver the speech. And does the president has a discretion in changing or altering this particular speech? In fact, the constitution does not explicitly say anything, but we know that the president has to act in accordance with the aid and advice of the Council of Ministers. So therefore, there is no discretion that is there explicitly. The president will come and deliver the speech on behalf of the government, and once the speech is delivered, then to thank the president for this particular speech, a motion is introduced. That is basically what is called as motion of thanks. And this speech is usually introduced by the Prime Minister himself in the Lok Sabha and by a very important minister in the Rajya Sabha. So after that motion is introduced, the opposition may not agree with everything in the speech, because of course they are likely to oppose the government. So then there will be a discussion on this, and then finally it will be put to vote. And when it is put to vote, if this motion is passed with, if it is not passed with simple majority, then that amounts to no confidence motion against the government. Okay, it is automatically deemed. And if it is not passed in the Rajya Sabha, there is no effect to the government. Okay, so only in case of Lok Sabha it has to be passed. Similarly, the same thing will happen in what is called as the state legislature as well. So please come here. The motion is passed during the first session of the parliament every year after the presidential address. Is it true? Yes. The defeat of the motion in the Lok Sabha shall be considered to be a vote of no confidence. Is it true? Yes. So which of the statements given above are incorrect? It is neither 1 nor 2. Okay, come to the next question. Consider the following statements with regard to the private member bill. So what is a private member bill? Any bill which is introduced by a person who is a member of parliament but not a minister. So sometimes students have a misunderstanding that a private member bill is from an opposition party. Not, it can be from the ruling party or the opposition party, but someone who is not a minister. A bill which is introduced by a member of parliament from the opposition party, no, it can be from the ruling party or it can be from the ruling party, but who is not a minister. A constitutional amendment bill can be introduced by a private member. Is it true? Can a constitutional amendment bill be introduced by a private member? There is no such restriction as to who can introduce a constitutional amendment bill. It can be introduced by a minister or by a private member. But if a private member is introducing it, it cannot move forward apart from that. So he can introduce, that is not a problem. But unless and until they are having the support of the government, how they can get it passed? So therefore, it is very unlikely it will get passed, but they can introduce that. There is no restriction to that. So this is definitely true. Which of the statements given above are incorrect? One only. So come to the next question. The Speaker of Lok Sabha can be removed by a resolution passed by what? By effective majority. And effective majority in which house? In the Lok Sabha. It is only in the Lok Sabha, not in the other house. Elected by what majority? Speaker. Which of the following statement is true with regard to the parliamentary standing committees in the parliament? Very important. So how many standing committees are there in the parliament? 24 standing committees in the parliament. Of these 24 standing committees in the parliament, how many committees are housed in the Lok Sabha? So 24 DRSCs. So this is what you will have to understand. So overall, of which there are 16 in the Lok Sabha and 8 in the Rajya Sabha. But every committee will have 31 members, and all the committees, it is a combination of 21 plus 10. That means all the committees in the Lok Sabha will also have members of Lok Sabha as well as Rajya Sabha. So here also 21 plus 10, 21 from Lok Sabha, 10 from Rajya Sabha. But the most important thing that you have to remember is, in case of DRSCs, all the members are nominated. There is no election. In case of the financial committees, we have seen that there is an election. That there is an election, and it is based on the principle of proportional representation. But here everything is what? Nomination. The Speaker will nominate all the 21 members. The Chairman Rajya Sabha will nominate all the 10 members. So there it is same in both the cases. In all these 16 committees, anyone from the Lok Sabha will be made as nominated as a chairperson. For all these 8 committees, anyone from the Rajya Sabha will be nominated as a chairperson. And what are the functions of these DRSCs? Normally they scrutinize the relevant bills, they scrutinize the budget relevant to them, they scrutinize the implementation of various government schemes which is relevant to them. So these are all some of the functions that is performed by the DRSCs. Okay, now come here. The members of these committees are usually elected for a term of 1 year. Are they elected? No, they are nominated. 1 year term, but they get again repeatedly nominated. The committees have representation from members of both the houses. Is it true? Yes, they do have representation. The committee help in discharging various functions of the parliament, including scrutinizing bills, implementing various schemes of the government, etc., thereby help in ensuring the accountability of the executives. Is it true? That's a general essence and functions of these committees. So choose a correct option from the codes given below. What is the answer? Option C only. Parliamentary committees, again I am repeating, very important. Come to the next question. Okay, so come to question number 209. Consider the following statements with regard to the procedure to amend the Constitution of India. A constitutional amendment bill can be introduced only in the Lok Sabha with a prior recommendation of the President. Now, one of the procedure that you should know is a constitutional amendment bill can be introduced in either houses of the parliament, and there is no need for any prior recommendation. It can be introduced either by a minister or by a private member. A constitutional amendment bill seeking to amend the federal provisions of the constitution also requires ratification by more than half of the state legislature, approved by both the houses of the parliament by special majority. Is it true? Is it true or false? Why it is, what is the mistake here? A constitutional amendment bill seeking to amend the federal provisions of the constitution requires ratification. It is not more than half of the state legislature. It is not less than half of the state legislature. There is a difference between these two things. Okay, so more than half is different from not less than half. Why it is there's a difference? More than half, 28 states, more than half means 15 states, but not less than half means only 14 states. So therefore there's a difference between these two words. So exact word that is given is very, very important. Not less than half of the state legislature after approved by both houses of the parliament by special majority. So in fact this is true, special majority is true, but it is because of not less than half of the state legislature. So this is wrong. The president can exercise his veto powers under certain circumstances when the bill is presented for his assent. This is regarding to a constitutional amendment bill. Can he use his veto powers? In fact, the 24th Constitutional Amendment Act 1971 makes it very clear the only option that the president has is to give the assent. Okay, so therefore this is not true. So which of the statements given above are correct? None of the above. Okay, so I will try to complete another 15 questions before I wind up the day. Huh? At what time? 5 o'clock, exact 5. Which class? Okay, they will come and inform me. Let me see. If they inform, I will leave it. Otherwise, I will extend it. Okay. So whenever there is a class, they will come and inform me. Okay. So come to the next one. So Santosh Sir class will go for another 3-4 hours. Huh? Okay. So which subject is dealing today? Economics. Related to the prelims only. Okay. Consider the following statements regarding the parliamentary privileges under the Indian Constitution. Statement 1. The parliamentary privileges are kind of special rights and immunities given to the members of the parliament and of the state legislature presently regulated by an act of parliament. What is the article related to parliamentary privileges? It is article 105 in case of the members of parliament, article 194 in case of the members of the state legislature. There are two explicit privileges which is given in the constitution. What are the privileges? Right to freedom of speech and the right to publish under the authority of the parliament, and the right to publish the proceedings in the parliament under the authority of the parliament, which also includes the right to expunge. So these are the two explicit privileges that is given in the parliamentary privileges. I am repeating it again, right to speech, but again this right to speech is not absolute. This right to speech is subject to the other provisions of the constitution and the rules of the house. That means just because the members of the parliament have the right to freedom of speech, they cannot use unparliamentary languages and start abusing one another. And just because they have the right to freedom of speech, they cannot engage in what is called as a contempt of the court or contempt of the judges. So therefore it is subject to the rules of the house and the other provisions in the constitution. The only advantage is that because they have the right to freedom of speech, they are not liable to be prosecuted in a court of law for whatever they have said in the houses of the parliament. So that is their privilege. And then the second thing is they also have the right to publication, which means whatever is a proceeding that is happening in the parliament, under the authority of the parliament, they can publish it. But which also includes the right to expunge, which means if certain proceedings in the parliament are expunged, then they should not publish. If they publish that, then that amount to contempt of the parliament. So there they can be punished, or it can be seen as the breach of the privileges of the parliament. So but who is authority to expunge? It is a presiding officer of that particular house. So today a number of controversial debates in the parliament, they are all expunged. So who is authority to do that? It is a presiding officer. On behalf of the house, he will do that. Now these two things are explicitly given in the constitution. But apart from that, if any of the other privileges are to be exercised by the members of the parliament or the state legislature, the constitution says that the parliament can make a law and they can confer more privileges. And for the members of the members of the state legislature, and for the members of the state legislature can make a law and they can confer the privileges. But till this point of time, no such law has been made. So therefore, what is a privilege that is exercised by the members of the parliament and the members of state legislature? Whatever is there in the constitution. But apart from that, the constitution says till the time such a law is made by the parliament or the state legislature, the members of the parliament and the state legislature can continue to exercise such privileges as it existed before the commencement of the constitution. Before the commencement of the constitution, they exercise a privilege in the form of conventional practices. So therefore, today what are the sources of parliamentary privileges? Whatever is there in the constitution and the conventional practices, and this is likely to continue till the time the parliament makes a law, and today we do not have a law. So with that, you try to answer this particular question. The parliamentary privileges are the kind of special rights and immunities given to the members of the parliament and the state legislature which are presently regulated by an act of parliament. Is it regulated by an act of parliament? No, it is not regulated by an act of parliament. But can the parliament regulate it? Yes, there is such a provision. The parliamentary privileges are subject to certain provisions of the constitution and rules of the house. Is it true? Yes, so this is definitely true. So what is the answer? Which of the following given above are incorrect? What is the answer? One only. Come to the next question. Which of the statements given above are correct? I have another 5 minutes to 5 also. Huh? My class is still 5. How can I leave it early? My class is still 5 o'clock. Okay, so anyways, the next teacher will give you time. Don't worry. 5 minutes you can get it from the next teacher. So which of the statements given below are true? So what is the answer? The speaker and the deputy speaker of the legislative assemblies should be elected in a time bound manner. Is it true? There is no time limit to elect the speaker and the deputy speaker. Okay, so the date of the speaker is decided by whom? President, and the date of the election of the deputy speaker is decided by the speaker. Okay, so there is, but it is not done in a time bound manner. The speaker submits the resignation to the Secretary General Lok Sabha if the post of the speaker is vacant. Is it true? Yes. And so is the case with the deputy speaker also, if the post of the speaker is vacant. The speaker and the deputy speaker can be removed by resolution passed by an absolute majority in the house. No, it is by effective majority in the house. Any person, even without being a member of the house, can be elected to the post of the speaker or deputy speaker, but they have to get elected to the house within a period of 6 months. Is it true? No, the only condition is they should be a member of that particular house. So what is the answer here? It is 2 only. Come to the, I will do it till 2:15, just 4 more questions. There are 3 more minutes, I will complete it. Okay. In the year 2021 marked a centennial year for the Public Accounts Committee of the Parliament. So 1921 this convention was established. Now it has become the part of the rules. In this context, consider the following statements. The Public Accounts Committee has members from both Lok Sabha and Rajya Sabha elected for a term of 5 years. It has members from both the houses but elected for a term of how much? 1 year. So this is wrong. As a parliamentary convention, the chairman of the committee is appointed from the opposition party starting there 1967. Yes. So this convention we are following till since 1967. This is true. They play a central role in ensuring the financial accountability of the governance to the parliament, because the Public Accounts Committee is going to scrutinize the report of the CAG, and the CAG report is very, very important in ensuring the financial accountability. So this is true. So which of the statements given above are correct? 2, 1, 3 only. Come to the next question. Which of the following is or the possible reasons for having the second chamber or the Rajya Sabha under our parliamentary system? What is the reason for having the Rajya Sabha or the second chamber? The Rajya Sabha helps in institutionalizing the power sharing between the center and the states in a federal political system. Is it true? Yes, Rajya Sabha represents the classic interest of the states. So therefore, this particular statement is definitely true. At least that is objective as to why the Rajya Sabha was established. The Rajya Sabha offers checks and balances for greater executive accountability and can also be a platform for great talent and expertise. Is it true? Because the very idea of having nominated members in the Rajya Sabha is to bring in wide experience and people from diverse background and intellectual people. Therefore, this is true. Rajya Sabha offers checks and balances for greater executive accountability. Is it true? Say for example, if a government is having a brutal majority in the Lok Sabha, they can amend the constitution to any extent, but the Rajya Sabha may not accept to that. So therefore, it is having certain element of checks and balances as well. So this is also true. What is the answer? Both 1 and 2. Okay, so this is part of your current affairs. Consider the following statements regarding Rule 267 of the Rajya Sabha. So many times today the opposition party wanted to have a discussion under Rule 267 of the Rajya Sabha, which means under Rule 267 of the Rajya Sabha, any business that has been listed on a given day can be suspended to take up a particular notice or to take up a particular matter that is to be discussed of urgent public importance. When this was highlighted in the Rajya Sabha again and again is when they wanted to discuss about the Manipur issue, when the Manipur violence was happening. So the purpose of having this Rule 267, this is only in Rajya Sabha, not in the Lok Sabha, is that whatever may be the business that is listed on a given day, all those business can be suspended, and what can be taken up for discussion? A matter of urgent public importance in case of what is called as Rajya Sabha. So with that, just come to this question. The rule allows a chairman to suspend the business of the house on account of a motion moved by a member to discuss a matter of issue of urgent public importance. Is it true? Yes. So this is definitely true. The rule has been invoked only once in the past to discuss the issue of demonetization in 2016. So whenever I said whenever only is there, 90% of the time it is what? 90% of the time it is wrong. But in this case, it is wrong. Okay, because as per the government sources, at least 7 times they have invoked since the commencement of the parliamentary system. Okay, so only once is wrong. Okay, so this is wrong. So which is the correct? Incorrect here. It is 2 only. Okay, last question for the day. Consider the following statements regarding the delimitation of constituencies. Okay, delimitation is a big topic. I'll take it up tomorrow because I want to discuss a lot of things under the delimitation. So try to revise all those things when you come tomorrow. So tomorrow I'll try to complete the entire thing, and we'll also start up the judiciary. Okay, thank you very much. If you have any questions, you can ask me later. Those who are attending the classes. Okay, thank you.